Advocate Makadam, good morning.
Good morning, Madam Chair.
Yes. You are reminded that you are still under your former oath.
Correct, Madam Chair.
Thank you. Good morning to you all.
Morning, Morning Chair.
Yes. Mr. Vani.
Good morning, Chairperson.
Good morning, Mr. Vani.
Chairperson, can I just check that I'm completely audible and visible?
Yes, you are both audible and visible, Mr. Vani.
Thank you, Chairperson. May I proceed?
Yes, you may proceed.
Madam Chair, I would like, if it's permissible, just to briefly put on record that I've clarified the position last night as to whether Josiah Leka Kala was crime intelligence or detectives. I spoke to two recently retired brigadiers who were stationed in police headquarters. The first brigadier confirmed that at January 2007, the date of that task team meeting, he was in crime intelligence. The second brigadier, who worked closely with crime intelligence, said he has all along been crime intelligence.
Thank you.
If that
Thank
will
you,
assist the
Advocate
Commission.
Makadam.
Thanks, Mr. McAdam. That's very useful to know and confirms your view that Detective Services was not present on the ITT. Now, talking of the ITT, before we return to your 2018 statement, I just want to wrap up a few matters from yesterday. Firstly, we promised to put up evidence of the relieving of Advocate Ackerman of his day-to-day duties on the TRC cases. And since this document from acting NDPP in share is not currently in the cross-examination bundles, my team have made copies, and I'm going to ask them to distribute to the commissioners and to Mr. McAdam. While they do so, I will just describe the document. It's dated 24 January 2008. It's from the acting NDPP Advocate Msher SC. It's addressed to Ms. Bandla, MP, then Minister of Justice. Can I just check that the commissioners and Mr. McAdam have their copies?
I do, Madam Chair.
Thank you. We'll be brief. I'm going to refer you to one passage. As you can see, it's titled Representations, Reverend Frank Chikani. It deals with the complaints raised by Reverend Chikani in an earlier letter in October 2007. And if we turn to the next page, it reads at paragraph 2, as a result of this letter and the prominent role played by Advocate Ackerman, I have deemed it prudent to relieve him from all TRC-related duties since November 2007. You see that, Mr. Ackerman?
I do. I note this is a letter written by Advocate Msher to the Minister, so I assume it would be accurate, which then doesn't explain the Annexure A, I think it was 18, where Advocate Ackerman notified Dr. Ramahiti that he was now withdrawing from TRC cases, and I would be taking over, unless that was as a result of this decision taken by Advocate Msher.
Yes. We're not going to have time to look into that presently, but it does seem that Advocate Mshe decided that he be removed from TRC cases, at least day-to-day duties. It does seem that at an arm's length, because he was still head of the PCLU, he occasionally dealt with certain matters such as deploying staff as yourself. I see in paragraph 3 and 4, Advocate Mshen notes the suspension of Advocate Bakoli, and he states that he's decided that all future post-TRC investigations and prosecutions be managed by Dr. Ramaite, Advocate Maga, and the TRC task team.
Madam Chair,
Yes.
it may be, as you'll see, that Advocate Marga was a senior state advocate, not a deputy. So perhaps the communication of June 2008 to Dr. Ramahiti was to put me as a deputy with lots of TRC experience to manage the portfolio, because Dr. Ramahiti runs a whole portfolio. He wouldn't do more than perhaps just attend strategic meetings, and what you needed is somebody with experience who can work full-time with the investigators. So that might explain the original apparent contradiction.
Yes, thanks. I think you're correct on that. And it does suggest that as he was still the head of the PCLU, and I suppose in charge of staff deployment. But if we can return to the ITT, the Interdepartmental Task Team, sometimes known as the TRC task team. And I want to draw your attention to the meeting held on the 4th of December, 2006. And it can be found in the bundle at page 433. Although before I proceed, we do want to put up some related documents connected to this meeting that appear to have been authored by Assistant Commissioner Jacobs. And I'm going to ask my team to do the distribution, because we don't believe that the 2 Jacob notes are in the current bundle. Mr. McAdam, do you have your copy?
I do. Is this the information note to Commissioner De Beer? And mine's not dated, but it's giving a list of cases.
Yes, that's correct. And then there should be another unsigned letter, which is dated the 6th of December 2006.
I see it.
Thanks. We're going to come to that shortly. I first want to focus on the minutes of the task team meeting on 4 December 2006. That's at page 433 of the bundle. Do you have that copy before you?
I do, Madam Chair.
Thank you. Firstly, there is an error on the date. It's recorded as 4 December 2007. I think we all agree that it was actually 2006. And I see that someone in handwriting has corrected it. Now, if one looks at the attendees, your name actually doesn't appear in the minutes there, but seems like that was another error in minute keeping, because actually your name does appear in the minutes themselves. So, for example, if you look at the bottom two paragraphs,
Yes, it's correct.
which looks like it's been numbered 4.6 and 4.7. Advocate Chris McAdam indicated that we need to adopt a wait-and-see approach, as all perpetrators will probably make representations in anticipation of prosecution upon completion of investigations. Then you also briefed the meeting on the Claire Stewart case. And if you turn the page, you can see you also informed the meeting of media reports on Highgate. Before we move on, since the... Yes. You want to say something?
No.
Okay. Before we move on, given that you briefed the meeting on the Claire Stewart case, and that is one of the cases that remains outstanding or unresolved through till today, do you have a sense, or can you recall what briefing you gave on the Claire Stewart case?
Yes, I do, Madam Chair. This matter related to, I think, a social anthropologist who was murdered in northern KwaZulu-Natal, and the initial investigation was indicative of her being killed in a murder and robbery. But I received some information that perhaps that was not correct, that the real reason is that she'd stumbled on a IFP training camp and they had murdered her to prevent her revealing the existence of this camp. So it was just on, and I can't remember if there was a representation written to me on it or whether I picked it up in a media report.
Thank you. And I assume that you weren't able to secure any further evidence or leads to take that case further?
I can't comment on that. All I can say is that when in 2008, Advocate Ackerman told me to take over the portfolio from him, this was not one of the cases that was identified as requiring further investigation. So I don't know if at a subsequent meeting, Advocate Marga looked at the material or whether this case slipped through the cracks. But it's not a case that I could say, here is solid evidence, if we investigate, we'll get a prosecution. It was simply me being proactive, saying, if there is any allegation relating to a TRC matter, I will look into it and see what it's about. Even if we do no more than write back and say, well, we checked it out, but we can't take it further. It could be also, with the delay between 2006 and the engagements with the police that started in 2008, this case slipped through the cracks.
Right, thanks for that. Let's then turn to an earlier paragraph that's at handwritten 4.5. It reads, Commissioner Jacobs informed members that he has sent a letter to Commissioner De Beer and the list of all investigators will be ready soon. Now, this is why we've attached this information note as well as the second letter, and they were put up in the Jacobs bundle. Commissioners, that's bundle 14, as PCJ 17 and 18. Now, the questions that I want to put to you in relation to these documents are very similar to the questions I put to you yesterday in relation to the DSO cases that were meant to be investigated. Let's start with the information note. Firstly, you will note that it is undated and it's unsigned.
Yes.
We can only speculate, but we assume that it must have been post or must have been around that time. So I suppose we're talking December 2006. And it reads as follows: information note. It's addressed to Divisional Commissioner Detective Service J.F. De Beer. And if you look at page 3, it's from Head Legal Support, P.C. Jacobs, titled Request to Make Investigators Available, the NPA Outstanding TRC Cases. And then let's just jump to the cases that needed to be investigated. These included PEPCO 3, Product 4. You can see I'm reading from paragraph 4
Yes.
onwards. Yeah. And then if we turn over the page, 4.3, State versus Hunty Burta and others. 4.4, State versus Kutsia. And we suspect that that's in fact the Nokuthula Simelane case. 4.5, COSAS 4. 4.6, you can see Heidelberg Tavern and St. James Massacre pops up again. 4.7, Kala, and 4.8, Mos Manude. And let's then turn to the next letter, PCJ 18. This one is dated 6th of December 2006, but it's also unsigned. As you can see, the reference is from Assistant Commissioner P.C. Jacobs, though it's in the name of Divisional Commissioner Detective Service De Beer. And it's titled Investigating Officers to Assist in Finalizing Cases Emanating from the TRC, and it's addressed to the various provincial commissioners. And under paragraph 2, they are requested to make 5 officers available from the various provinces and 1 from head office. Now, so as mentioned, the questions are going to be similar. Firstly, do you know whether investigating officers were in fact appointed to those cases? And if so, do you know who? And were they the individuals mentioned in paragraph 2, that last letter?
No, Madam Chair. When I was instructed by Advocate Ackerman in June 2008 to get the tasking up and running and obviously investigate. At that stage, no investigators had been appointed. I wasn't shown any investigated dockets at all. I had to start again with the list that was provided to first General Lala and then to General Labia, and then 2010 the investigators were appointed for those cases.
Thank you. Then one returns to the information note. Some of the cases we are quite familiar with the more well-known ones: PEPCO 3, Product 4, Nokuthula Simelane, COSAS 4, Heidelberg Tavern, St. James Massacre. And as we discussed yesterday, some of these matters are only coming before inquest courts in recent years. For example, PEPCO 3, that's only been heard in October of this year. Product 4 is currently before an inquest court. COSAS 4, we know that charges were preferred in 2021. That's ongoing. Nokuthula Simelane, those charges were only preferred in 2016. In respect of the other cases, do you have any knowledge as to whether they were taken forward at this time?
Madam Chair, I can confirm all the cases that either a prosecution was instituted or inquests were held or started only from 2010 when the Crimes Against the State unit of the police started investigating those matters.
Thank you. All right, then one last matter arising from the work of the ITT. And I want to refer you to a document which is at page 60 of the SAPS updated bundle. So the bundle that my learned friend was from SAPS was relying on yesterday. I'll just wait for you to find it. This is a letter from National Commissioner Celebi to Advocate Corley. It's dated 6th of February 2007.
We're still struggling to find it, but perhaps you can put it to me what's there and I can respond to it without having to see the document.
Right. Let me quickly check with my team whether they have additional copies of this, which might be of assistance.
We now have a bundle. If you can just give me the page reference again.
I'm told that it's from page 60.
Mr. Vani,
Yes,
on
Chairperson.
page 60 of the SAP supplementary affidavit, we've got the investigation diary.
I see. All right, and then I'm going to have to rely on my team to find the page number, because I was told that it was on the SAPS updated bundle from page 60 to 67. Ms. Piller, can I ask whether you have found the correct reference for the Celebi letter?
Chair, my colleagues are assisting us and they advise us it's page 66. Thank you, we're grateful.
Yes, it's page 66. Mr. Vani, I think it's page 66.
Thank you. I'm indebted.
Outstanding TRC cases
Yes, that's exactly it.
from the national, it's dated the 6th of February 2007.
Yes, that's the
Yes.
letter in question. Thank you, Chairperson. Mr. McAdam, you have that letter before you.
I do, yes.
Right. So it's a letter from National Commissioner Celebi, as the chair indicated. The second page, you can see in handwriting, it's dated 6th of February 2007. Addressed to Advocate VP Picoli. And the exact same letter was also sent to other members of the task team, including the Department of Justice and National Intelligence Agency. It's titled Outstanding TRC Cases. I'm just going to read into the record a portion of this letter so we're all on the same page. Starts, I have been briefed on the last meeting of the task team set up in terms of the Cabinet guidelines on outstanding TRC matters. It was brought to my attention that in SV Otto, complainant Reverend Carney, a decision on prosecution was taken without consultation with the respective departments. I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Directors General will have an opportunity to provide input before a decision on prosecution is taken. I'm also under the impression that there is no common understanding on the process to be followed. My understanding was that the officials designated on the task team by the Director General will provide recommendations to the Director General, who will, as a collective, advise the NPA as the decision maker on prosecutions. Next page. In my view, a comprehensive report such as the one directed to the NPA dated 24 November 2006 and revised on 29 November should be discussed by the Directors General. Although I do not insist on a meeting with the Directors General after each meeting of our officials, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Director General before a decision is made. I'm going to pause there.
We don't have the second page, unfortunately, but with you reading it in the record, I fully understand it and can answer it without that page.
My apologies for that. Perhaps my team can, in the meantime, furnish a second page to you. But thank you for allowing me to continue. Now, in response to this letter, Advocate Pakoli said he was going to raise the issue with then Minister of Justice Mabandla. And I want to refer you to what NDPP Pakoli wrote to the minister at the time. And his memo can be found at page 210 of the bundle. And I'll just wait for you to get there.
Ah, there we are.
Thank you. So you can see it's a secret internal memo addressed to Minister Mabandla. It's from Advocate Pakoli. It's titled Prosecution of Offences Emanating from Conflicts of the Past, Interpretation of Prosecution Policy and Guidelines. It's dated 15 February 2007. It's quite a long memo, so we don't have time to go through the memo.
I am
as a
familiar
whole.
with it. I attached it as an annexure to my affidavit in the Rodriguez matter.
Yes, indeed. And as you can see on that first page, it's titled up on the right, RCM 17, which confirms that that was one of your annexes. But if I can ask you to jump to page 219, there are just two paragraphs that I want to put to you. Those are paragraphs 4.6 and 5.1. So it deals specifically with the procedure that Commissioner Salebi was insisting on. 4.6 reads, the NPA cannot agree to the above proposal. The effect thereof might be that the National Director would be obliged, as is suggested by the National Commissioner, to wait for the finalization of the proposed process before he may make a decision whether to prosecute or not. If the task team or the Committee of Directors General, in spite of a reasonable prospect of a successful prosecution, unnecessarily delays the process, the National Director would be prevented from complying with the prosecuting authority's constitutional obligation. Therefore, such a process would be unconstitutional. And then under the heading Conclusion and Way Forward, 5.1, there's clearly a misunderstanding regarding the role of the task team and the role of the relevant state departments referred to in that amended prosecution policy. In accordance with the approved amended prosecution policy, the NPA is of the view that the duty of the task team or the relevant state departments is to assist the NPA in the execution of its duties. However, nothing prevents the task team or the departments, whether individually or collectively, to make recommendations to the National Director, provided that the National Director should never be in a position where his constitutional duty is dependent on the recommendation of such a task team or relevant department. Such a procedure would be unconstitutional. Do you agree with the view of Advocate Pakoli that what Commissioner Salebi, with the support of the DOJ and NIA, were wanting to do, which is require the NPA to wait for their recommendation, that was unconstitutional.
Correct, Madam Chair. It's also in direct conflict with the NPA guidelines, which were confirmed by Parliament and came into effect 5 December 2005. It specifically stated that the police, NIA, Justice, and the DSO should nominate one official from their departments to assist the PCLU. What the Commissioner is relying on is reviving the what was stipulated in the Amnesty Task Team of February 2004. That contemplated a committee which would advise the National Director on each and every case that he had to take. And clearly, Madam Chair, the Constitution and the NPA requires that the NPA perform its prosecutorial without fear, favour or prejudice. But I also agree with Advocate Bakoli that it's going to unnecessarily delay the process, because now the task team members must write to their DGs, the DGs must then write to Advocate Bakoli. I've seen correspondence addressed by Commissioner Jacobs to Advocate Marga, where he says no, the NPA must hand over all their files to the task team, and they will then go through all those dockets. How long is that process going to take? We're looking at half a dozen departments. And what can they really contribute to the matter? If this thing properly functioned, any issues which needed to be brought to the attention of the NPA could be dealt with at that level. For example, if the police said they have clear evidence that the only witness is going to retract his statement, and that will result in that can be brought to us and dealt with. The same thing if the intelligence agencies say, but there are these sinister moves afoot in a specific case, somebody will come forward, but he'll be planted there to infiltrate the investigation. That can be brought to our attention and taken into account. I can't see what recommendation Justice can do, because their sole function was to deal with any reviews of amnesty decisions after the TRC dissolved, and secondly, to facilitate fast access to the files. In 2007, the DSO was on the point of being dissolved. So what further contribution could they make to the matter?
Thank you. And I think you raise an important observation in relation to the DGs when you state, what contribution can they make? I mean, directors general, they are in charge of executive departments in government. They're not involved in investigation of cases. What possible contribution or input could they make in relation to a decision to prosecute or not?
And may I take this further? Look at the National Commissioner of Police. When he wrote to Advocate Bakoli in 2007, Advocate Nell and Mr. Least were at an advanced stage of planning to arrest and prosecute him for serious corruption offences. When you look at the Director General Intelligence Agencies, I believe in 2010, he had to resign after an investigation established that a principal agent network, which he had authorised, had resulted in massive financial fraud, mismanagement, corruption on the part of the persons in that network. If we look at the DG Justice, I mean, it is correct that he testified at the Jinvala inquiry. The inquiry made serious findings against him, and when he became the National Director, the Constitutional Court and the SCA found that he was unfit to hold office. So what value are we going to attach to high-ranking officials with those serious issues hanging over their heads.
And if we turn to the next page of that memo, I'll just read one further passage to you, because it now seems that this is the last straw for Advocate Pekoli. And he writes at paragraph 5.2, I've now reached a point where I honestly believe that there is improper interference with my work, that I'm being hindered and or obstructed from carrying out my functions on this particular matter. Legally, I've reached a dead end. Would you agree that the attempt by then Commissioner Salebi and indeed NIA and the DOJ, that this was another attempt at executive intervention in prosecutorial discretion?
Correct. They were usurping the powers of the MPA. Madam Chair, may I also add that with this letter of Advocate Pekoli, when I filed it in the Rodriguez matter, he gave me a confirmatory affidavit confirming that he never received a reply from the minister to that letter.
Yes, and I believe he also confirmed that before this commission. Mr. McAdam, can I ask you to return to your 2018 affidavit at red paginated number 144.
Correct, I have the page in front of me.
Thank you. So yesterday, I believe we managed to get to paragraph 39. And just so that we can speed along, we won't deal with paragraph 40. You do indicate that the foreign bribery cases were taken away from you, and then you were able to focus attention on the TMAL and agate matters. But can we drop down to paragraph 41? Now here you mentioned that Advocate Johnson, and I assume that that's Advocate Andrea Johnson, is that correct? Correct. Who was at that stage acting as the head of the PCLU. And I read, informed me and a senior state advocate who was assisting me with the cases that we should not continue to work with the TRC cases as they were going to be removed from the PCLU. Firstly, did you recall who the other senior state advocate was?
Yes, it was Advocate Susan Bokau.
Thank you.
But that Johnson, is it Advocate Andrea Johnson?
That is correct, Commissioner.
Yes, thank you.
McAdam, was that not an extraordinary instruction that you should not continue to work with the TRC cases as they were going to be removed from the PCLU?
Yes, Madam
and indeed, you state. Sorry, go ahead.
The background to this is Advocate Abrams was appointed as the National Director in 2015. Immediately, Advocate Mkhwebe called for all the foreign bribery cases to be taken away from me and being given back to him. This resulted in a meeting with Advocate Abrams, Advocate Mkhwebe, myself, and there were two other advocates also in that meeting. And what I said in that meeting is that I said, look, if me continuing with foreign bribery is causing all this unpleasantness within the MPA, I would be willing to hand those cases over, and I'd willing to again work on TRC cases, because I was seeing that there was a need for those cases to receive the attention of an experienced prosecutor who had the necessary knowledge. Mr. Abrams said, no, I mustn't do that, because he is on the point of taking the TRC cases away from the PCLU so that there can be a fresh look at them. Now, when this impasse, because what happened, so he said, no, you stay on foreign bribery. Step 2 was Advocate Mkhwebe, notwithstanding that decision by Advocate Abrams, instructed the police to give him all the dockets and not to me. I then wrote to Mr. Abrams saying, I take it now, I'm off. He wrote back, he has not cancelled my appointment, and in fact, he's authorized that I must now go and attend to 2 OECD meetings in Paris. Then the next step is, of my own accord, I realized there was a problem with TRC cases, and then I started working on agate and timol. And then I think it's an annexure to my March statement, is that Dr. Pretorius became the head of the unit, and he then asked for a report from me on what I'd done on agate and timol. And there I said, please clarify with the national director what the position is as far as where these cases are going. Are they going to stay with us, or are they going away? And if they stay with us, I also flag staff shortages, etc.
Thanks for that for that clarification. And I suppose it's yet another example. And I'm struggling to find the right words. Perhaps blunders are the right words, missteps, because this kind of indecision. Would you agree, on the part of the NPA at this time, eroded the progress on the TRC cases?
That is correct. This issue of saying my appointment to do foreign bribery has not been terminated, but I have no access to the dockets, was raised at the Mahoro inquiry into the fitness to hold office of Advocate Mkhwebe, and the Commission spoke very strongly about how inappropriate this was.
If we just return to the instruction given by Advocate Andrea Johnson, I just find it gobsmacking that the instruction wasn't, look, continue working on the cases while we decide where they're going to be located. Instead, it's you should not continue to work on the cases while they decide. So the impact is that you have to down tools pending a decision.
I agree with you. I mean, there's no, as I said, we continued working on the Timol matter despite this, and as you were the counsel in that matter, you can confirm there was no prejudice because of me continuing to work despite the fact that we were told not to work on the matters.
Yes, and we are grateful for your initiative in that regard. Let's move on. So in paragraph 42, as you indicated, in February 2016, you're approached by Dr. Pretorius SC, who by then had taken over from Johnson as head of the PCLU. He informs you that a request has been received to reopen the inquest in agate and the Timol cases. You attached your opinion, and actually in that document which you attached as RCM 8, there is an interesting passage which I think underscores your point. So let's go to it. It's a page 169. And the passage in question is at 174.
I have the document in front of me.
So, Commissioners, you can see that this is an internal memo from Advocate McAdam to Dr. Pretorius, as dated 4 February 2016. Opinion, reopening Timor stroke agate inquest. And if we can just jump to 174.
Yes, I have that page already. I take it paragraph 12.
Yes. Paragraph 12, indeed. Can I ask you to read into the record, not the whole paragraph, down to the word finalise the matters timelessly?
Having said that, it has to be in the strongest possible terms stated that it is imperative that the NDPP must make a decision as to whether the TRC cases must remain with the PCLU or not. It serves no purpose to decline the request. That is, that we were going to say we're not going to reopen the inquest before we've made a decision that we should not charge for murder. Be placed in the position that 2 or more years down the line the cases have not been finalised because either the DPC or NPA or both are unable to commit the necessary resources to finalise the matters timelessly. Must I go on? It says it must be.
No, we can pause there. But, now that you've read that into the record, am I right in saying that reflected some alarm that you had and a great deal of uncertainty and instability in respect of the management of the TRC cases?
Correct. As an advocate, you need to know exactly what your work is. So if this is hanging, this uncertainty makes it very difficult to do focused work or so. But may I also say, with Advocate Abrams, from March 2013 until 2014, when Mr. Kasana demoted him, he was acting as the head of the PCLU. On a monthly basis, I reported to him on on all the cases, progress, difficulties, etc. After he was demoted, and until he became the national director, he was now the state advocate dealing directly with these matters. He was obliged to report every month to Advocate Johnson on what was going on with these matters. So I would say he was ideally placed to know what the issues were, and this is not something that you can leave hanging in the air while you think about perhaps taking it away, etc. He knew the urgency of these matters.
Let's move to the next paragraph. And here you're dealing with the Timor matter, and you make reference to a report addressed by Ackerman to Ramaite and Bakoli, dated 30th October 2006. And since you mentioned the role of Superintendent Brits yesterday, it features in that report. Although before we go to that report, I want to refer you to a memo, an earlier memo that you addressed to NDPP in Guka back in 2004. This is at page 409 of the bundle.
We're just turning to the page. Oh, there it is, yes. I have it before me.
Thank you. And Commissioners, I also assume you have it as well. So it's an internal memo, as mentioned, addressed from yourself to then NDPP in Guka. It's titled Investigation Against the President and Other Prominent ANC Leaders. It's dated the 5th of July 2004. It's signed both by yourself and Ackerman SC. It reads, 1, I normally do not allow myself to be distracted by such matters, but given the manner in which Commissioner Salebi sought to attack you over the above case, the following is of interest. Paragraph 2. On 5th July 2004, Senior Superintendent L. Bester and Superintendent H. Brits of SAP's headquarters saw me in connection with the attached memo confirming the NPA's decision not to conduct an investigation. They were displeased with the contents of the memo and attempted to persuade me to reopen the case against the President, as there was an abundance of evidence to justify a prosecution. I have invited them to furnish me with dockets containing such evidence. 3. During these discussions, Mr. Ackerman joined the meeting and drew their attention to the fact that since June 2003, he had invited them to produce evidence implicating the President without any success. I'm now waiting to see if any dockets will materialize and will inform you accordingly. So yesterday, I drew your attention to the fact that Senior Superintendent Bester seemed to have a preoccupation with putting together cases against the ANC, in particular the ANC leadership. And here you have Bester and Brits knowing that the NPA have now made a decision in the matter and coming to tell you that they are displeased with that decision, given the abundance of evidence. What did you read into that?
You see, what had happened is the allegation against Mr. Nuka by Commissioner Salebi had already been investigated, and we had demonstrated that his claims were false. And what happened there is that I had given my report to Mr. Nguka, setting out all my reasons why there was no such case. While I was working, Mr. Nguka, accompanied by Minister Maduna and Mr. Billy Mtsetla, a security advisor to the President, came into my office. I then explained the basis for my decision. They put questions to me, I answered them. I said, look, if there's any doubt on this matter, I'm willing to take you through, all the material I worked. Then the minister said, no, that's not necessary. He then stepped out of my office, standing on the other side of the door, and Mr. Maduna has got a very loud voice. I heard him say to somebody, put me straight through to the President. I didn't hear what the next exchange was, but he said, if Salebi is making that allegation, he is lying. So I don't know if this was now orchestrated by Commissioner Salebi to gain credibility by saying, here you are, McAdam admits he's made a mistake, and here is his letter directing further investigations, if that was the motive. Or whether it was just Brits, being an old security branch member, still wanted to settle scores with the ANC. But I can confirm, Madam Chair, what I did is I did not have time to read the 400 dockets, but I went through the register that was given to me. President Mbeki was not listed as a suspect in any of those dockets, in contrast to other cases where General Nyanda, General Shawke, other prominent members of Mkhonto Sizwe were. I can confirm, furthermore, that the only docket that they identified to Advocate Ackerman and I for prosecution, and this was before Commissioner Salebi made his allegations, was the Blarney matter, and that matter was in fact prosecuted by us. And the follow-up to this is, I said, bring the dockets, because I always said, fine, if there is evidence, I must reassess my decision. The story then changed, no, all the material is with retired National Commissioner Johan van der Merwe. Now, the question is, what is a former National Commissioner sitting with evidence that implicates the President of South Africa. If he had any such evidence, he should have handed over that material to the person who replaced him as the National Commissioner, George Fivers, so the matter could be properly investigated, as the law requires. But to dispel this story once and for all, and I think the affidavit from Mr. Least is attached to one of my affidavits, or it's filed with the inquiry, is that Mr. Least said he went to Mr. van der Merwe, he confirmed he's got a lot of evidence, and he will submit it to Mr. Least via his attorney. No such material was handed over to Mr. Least. Mr. Least informed me that thereafter, every time he made an appointment to see Mr. van der Merwe, he would cancel or not be available. And then the final straw is after the plea and sentence agreement in the Reverend Frank Tishkani matter in 2007, their attorney, Mr. Wagner, the same person mentioned in the affidavit of Mr. Lees of March 2004, then writes to Advocate Bakoli saying that the MPA must focus on one single landmine incident and look into the role of the NEC. And that particular case referred to by Mr. Wagner is one where people were arrested, convicted, and thereafter they were granted amnesty. And how can you then prosecute the president on one single landmine incident? And in that case, it was simply planted on a farm road, and two families traveling in a car were the victims in this case. Not a high value target for the ANC, for example, a senior military or police commander or an intelligence agent who'd infiltrated them.
Thank you. We will turn to a document that I think will speak to some of the issues you've just raised. Chairperson, I see it's almost 11 p.m. Would the chairperson and commissioners wish to take the tea adjournment?
Mr. Vani?
Sorry, AM.
Yes. Yes, I think this will be an appropriate time to take a tea adjournment until 11:15.
As the chair pleases.
Are you well settled, Advocate McAdam?
Correct, Madam Chair.
Thank you. Mr. Vani?
Thank you, Chairperson. Mr. McAdam, with regard to the evidence you were giving just before tea time, I want us to return to paragraph 43 on page 145. That's paginated red number. And you make reference to a report that Dr. Pretorius showed you, a report addressed by Ackerman to Ramaita and Bakoli dated 30th October 2006. And you attach that report as Annex RCN 10. That report is...
I just need to turn to that annexure because out of my head I don't know what the text of that document is. If I may do that.
Yes, that's exactly what we're going to do. So the front page of that Annex RCM 10 is at page 176.
I have it here.
Good. So it's an internal memorandum. It's from Advocate Ackerman SC. It's addressed to Dr. Ramaite, copy to Advocate Pauli, and copy to Advocate K. Pillay. There are two subject matters: details of TRC cases closed by the PCLU, and secondly, reappointment of Senior Superintendent Brits. And as mentioned, the date is 30 October 2006. Now, for current purposes, I want to deal with that second topic, reappointment of Senior Superintendent Brits. So if I can ask you to turn to page 10 of the memo, it's at red paginated number 185.
Yes, I have it.
And at paragraph 2.28, that's titled The Reappointment of Senior Superintendent Brits. Now, there are several paragraphs here, but I think it is important that we put all of them on the record. So I'm going to read them into the record and then pose some questions to you. So starting at 2.28.1, at its last meeting, the committee was informed by Assistant Commissioner Jacobs that Senior Superintendent Brits would be reappointed to investigate the dockets in possession of SAPS. Sub 2, I wish to express my concern at this. Brits was a former member of the security branch who, prior to the PCLU being involved with TRC cases, assisted the DPP Pretoria with cases involving the liberation movement. Sub 3, former Police Commissioner General van der Merwe had formed an organization entitled the Foundation for Equality Before the Law, which was intended to ensure that no further prosecutions of security branch members would take place. Sub 4, I and my staff were appointed to take over the TRC cases in the DPP office, Pretoria. We gained the firm impression that Brits was not only very sympathetic toward this organization, but had regular contact with General van der Merwe. Point 5, in particular, Brits tried to persuade me and my deputy on numerous occasions that there was a provable case of terrorism against President Mbeki arising from the landmine campaign. This was raised in the context that there were security branch members to be prosecuted. I think that the word if is missing. The president would also have to be charged. It was clear that he was against prosecutions of security branch members. Despite his claims, he could never produce a docket implicating the president. At one stage, he informed me that the docket was with General van der Merwe and his legal advisor. This raises a very serious question as to how an official police docket could be retained by General van der Merwe was not entitled to possess police material after his retirement from SAPS. Sub 6 on the next page. When the issue of prosecuting security branch members for the PEPCO 3 incident was raised with their lawyer, he immediately indicated that he was preparing to submit a docket calling for the prosecution of the president. I can only draw the inference that the sharing of information took place between Brits and Van der Merwe. Sub 7. The issue of the prosecution of the president was raised at the highest level of government and resulted in inquiries being conducted by Minister Maduna, as well as members of the president's office. All parties were satisfied that the NPA had no intention of prosecuting the president. In fact, Mr. Nguka had been provided with a report. No such case had been established in the TRC records. Sub 7. This highly embarrassing incident caused Mr. Nguka to instruct that Brits vacate the offices of the DPP and that all the relevant SAPS dockets be removed. Brits was subsequently relocated in the SAPS Crimes Against the State unit. He requested the PCLU to provide written confirmation of the fact that the decision had been taken not to prosecute the president. When he received the letter, he tried to persuade the PCLU to reconsider its decision. Sub 9. I therefore believe that Brits lacks the necessary objectivity to be of assistance to the committee, and that his reappointment may lead to further controversy, as well as the potential leaking of information to General Van der Merwe. So, having read those remarkable passages, does this indicate that, given the date of this memorandum being in late 2006, that there were elements within SAPS that still believed that there was a case to be made out against President Mbeki and other ANC leadership, and that these should be pursued, notwithstanding this earlier decision to close those cases?
That is correct, because when Mr. Nguka ordered the removal of those 400 documents, Deputy Commissioner Price and Deputy were present, and Mr. Nguka made it clear that he's ordering those removal of those dockets not to stop any further work on them, but simply to deny Commissioner Salebi the opportunity to make further false allegations. But Mr. Nguka said to the police, this does not mean that if you have a case where you need assistance from the NPA decision, that you can submit it, then we'll consider that individual docket. No such dockets were ever submitted at any stage to us after those two deputy commissioners were so instructed by Mr. Nguka.
Can you remind, sorry, Mr. Vani, Mr. McAdam, can you remind us why is it Colonel Brits was removed in the first place and subsequently reappointed? Who removed him and who reappointed him?
Commissioner, he was a retired police officer working on contract with a contract given to him by the police, who were then paying him his salary. So what would have happened is that when that contract lapsed, it was not renewed. And clearly here, what is stated was that Commissioner Jacobs was contemplating that he'll be again given a contract to again take over these dockets. The NPA, all we said, as far as the NPA was concerned, remove the dockets from our office. We didn't say the police must cancel Colonel Brits's contract.
Yes, thank you. Mr. Vani?
Thank you, Commissioner. And Mr. McAdam, there's a rather prescient comment that Ackerman makes in that last paragraph in sub 9. He says that if Brits is reappointed to deal with these cases, he says this may lead to further controversy as well as the potential leaking of information. leaking of information in the hands of the police. Do you think that concern of Advocate Ackerman was justified?
Correct, Madam Chair. Both Advocate Ackerman and I were in 2003, early 2000, firmly under the impression that Colonel Brits was sympathetic to the former security branch, and we also got the impression that he was in regular communications with Mr. van der Merwe.
And speaking of leaking of information, are you aware of a leak involving the very landmine case that you've referred to the press approximately 1 year later?
That is correct, yes.
So it does seem that Advocate Ackerman's concern had a real justification. Now, if I can draw your attention back to sub 5, where Ackerman writes in relation to the pressing for a case against President Mbeki, second sentence, this was raised in the context that there were security branch members to be prosecuted. I think he meant to say this was raised in the context that if security branch members to be prosecuted, the president would also have to be charged. It was clear that he was against prosecutions of security branch members. And then in sub 6, a similar sentiment is expressed by Ackerman in relation to the PEPCO 3 incident, where he mentions that their lawyer, and I'm assuming that's Wagenaar, said that he immediately indicated that he was preparing to submit a docket calling for the prosecution of the president. Now, did this reflect a tactic on the part of perhaps Commissioner van der Merwe and his organization, Foundation for Equality Before the Law, the representative of these suspects, Mr. Wagenaar, and perhaps individuals within the police, such as Brits, that this was a tactic they were using? If security branch members are to be prosecuted, well, then the threat is that they will ensure that that ANC leadership must be prosecuted as well.
I can't talk about the police that were involved after this, but Colonel Brits clearly tried to sell that story to Advocate Ackerman and I. I remember specifically him saying the TRC was such a beautiful process, we can't contaminate it because the prosecution of former security branch members will lead to the prosecution of the president, and that will have a major negative impact. He said that specifically.
Now, Advocate Ackerman, before this commission, has been accused of being an apartheid prosecutor who could not be trusted. Given that Advocate Ackerman is objecting strenuously the appointing of a former security branch officer who appeared to be, in Ackerman's view, bent on pursuing cases against the ANC leadership and appeared to be against prosecutions of security branch members, in your view, does that not undermine claims that Advocate Ackerman was not objective and that he was an apartheid prosecutor?
No, Madam Chair, in all my dealings with Advocate Ackerman, he never had an agenda that we've got to focus on the security forces. No, sorry, never that our priority is prosecuting the ANC leadership and we should forget about the security branch cases. You'll see in, I think it's AD, in those AD14 documents, which I attached to my affidavit, I had identified all the cases that we needed to look into the security force, and then Advocate Ackerman said he agreed with me, and that was the strategy endorsed by Mr. Nguka, and that was in our meetings in May 2003. And then he was involved in the PEPCO 3 case, which was a case against the security forces.
Let's return to...
Now, I just finish. He also, endeavored to have the SCA judgment in the vote of Basson appealed to the Constitutional Court. He had to, in the applications for leave to appeal, provide an affidavit. And that, if you read to that affidavit, you'll see this is not a person who is gunning for the ANC and wanting to protect the security forces.
Thank you. Commissioner Kummer?
No, that's fine. Thank you. Continue, Mr. Vani.
Oh, thank you, Commissioner. Advocate McAdam, if we can return to your 2018 statement on page 145 of the bundle, paragraph 44.
Certainly.
So now this is dealing with the Ahmed Timo matter. And I want to read to you a section of this paragraph. I'm going to start from the second sentence. And this deals with the investigation of an aspect of the Timo matter. If memory serves me correct, Leask had informed me that as a result of the decision taken by Ledwaba that the DSO would not investigate TRC cases, he was unable to comply with my original request for investigations. Since he was, however, traveling to Cape Town on other investigations, he contacted Ivor Powell, that was the journalist in question, and questioned him regarding the confession apparently made by the applicant in the matter. The allegation was, however, denied by Powell, and Mr. Kaji was informed accordingly. Now, as I understand it, it was on the back of that information that the Timo case was subsequently closed. Now, would you agree with me that that did not constitute an investigation of the case? It was simply Leask, who was not able to investigate officially, doing you a favor since he was already going to Cape Town on other matters. He made contact with Powell, who I understand had actually even joined the DSO by that time, and spoke to you and gave you that information, that was just closing a particular lead. It was not conducting an investigation.
That is correct, because if it had been an investigation, he would then have taken an affidavit from Mr. Powell and then set everything out in the affidavit. But more importantly, if you look at my tasking that I gave to Mr. Leask in May 2003, I am confident that if he had followed up those areas that I'd identified, that would have given me sufficient grounds to submit an application to Advocate Ledwaba to authorize a full investigation in terms of Section 28(1)A of the MPA. So then it could be officially investigated by the DSO using all the powers of the DSO, and every bit of evidence would have been gathered if it was available.
But as you've already indicated, that did not materialize because Ledwaba instructed that at least stop his work on the TRC cases, and we've already dealt with that saga. So in those circumstances, given that Leask was not able to address all the instructions you had previously given him, and given that only one aspect was looked into, that's set out here in paragraph 44, is there not some merit in Imtiaz Kaji's criticism of the closing of that investigation? Because it can't be said that an investigation actually happened.
That is correct. You see, this letter was drafted 2006 when I was full-time on the nuclear case. So what I suspect is somebody who'd taken over from me may have seen that letter that I wrote to Mr. Kachi in 2004, but not seen the previous letter a year previously, and seen that I wanted further investigations to be done. But clearly, when you have these breakdowns of continuity, it's this type of thing that does happen. Because if the DSO had not withdrawn, the matter would have been investigated already. Least would have got that information, and we would have known already in 2003 whether we have sufficient grounds to launch a full investigation.
So do you accept that the closing of the Timol investigation at that time, that was a mistake?
Correct, yes.
And I note in paragraph 45 that you point to a report dated 24 October 2006 addressed by Ackerman to Ramaita. And in that, we don't have to go to it, but in that report, cases are listed that are closed, and names of prosecutors are mentioned next to those names. Then next to the Timor case, there's no name mentioned. The commissioners, that's at page 192 of the record, if you do wish to look at it. Perhaps we can just go to page 192 quickly. And you'll see under paragraph 3 at the bottom, matters closed, death and detention, Ahmed Timol. It makes reference to that alleged confession to the journalist, which was followed up. If you turn the page, there's also reference to Bika and Nihas and other cases, and you'll see that names of prosecutors appear next to other case names like Nihas, your name appears, and several others. But there's no name of a prosecutor next to that of Ahmed Timol.
That's correct, yes.
All right. Let's then move on to the next paragraph. And here you indicate the research you did when you prepared this affidavit. Sorry, it's not paragraph 45, it's paragraph 46 on the next page. Here you point out that in December 2017, you were contacted by the NDPP's office manager, who requested you to collect certain of Pekoli's documents that he found in a strong room. You collected these documents, perused them, and in fact, you've attached these to your affidavit. Let's start with the first one, a second draft of an indemnity bill making provision for the president to grant indemnity to persons committing politically motivated crimes from March 1960. Now, if you turn to page 202, there's only the front page of that indemnity bill and then the preamble. Was the full bill not in the records at that time?
Madam Chair, if I can check, I suspect when I was this year looking for documents and going back to the MPA, I might have come across the full Indemnity Act. Because I think subsequent to my testimony in March, I found it. If that's the case, I will arrange for it to be supplied to Ms. Graham, who collects the documents on behalf of the inquiry, if that's appropriate.
We would be grateful. I think it would help to complete the Commission's records, and currently we only have those 2 pages. And then if we move on to the next subparagraph 46.2, the terms of reference of the Amnesty Task Team dealing with the criteria with which the NPA applies to TRC cases, formulation of guidelines and whether legislative enactments are necessary. And then you attach that as RCM 14. The Commission is familiar with the contents. And then 46.3, the further report of the Amnesty Task Team, inter alia looking into whether private prosecution and civil litigation can be eliminated where a decision not to prosecute is taken, and whether a person aggrieved with the decision could approach the International Criminal Court. And then the next subparagraph 4, a letter dated 6 February 2007, addressed by Pakoli to the then Minister of Justice.
February.
I beg your pardon?
Yes. A letter dated 8 February, not 6 February.
Thanks, Commissioner. I'm getting mixed up, and plus my eyesight is also failing me. So it's a letter dated 8 February, addressed to Pakoli by the then Minister of Justice, expressing her concern that the NPA was proceeding with the TRC prosecutions, as she was under the impression that the NPA would not. And you attach that as RCM 16. Perhaps we can turn to that one. It's at page 209 of bundle.
Yes, I have it before me.
So this is a letter from Minister Mabandla to Advocate Pakoli, dated 8 February 2007, titled TRC Matters. She refers to a discussion on the 6th of February. And then she writes, I must advise you at the outset that the media articles alleging that the NPA will go ahead with prosecutions have caught me by surprise. In our discussions, you briefly mentioned to me that the NPA will not be going ahead with the prosecutions. As you had undertaken to advise me in writing, I would appreciate it if you could advise me urgently in the matter so that there can be certainty. So when you read that, what impression did it leave with you?
Madam Chair, after this was filed, I was this year approached by Ms. Graham to look for documentation relating to the minutes of the task team and the communications between Advocate Pakoli and the other DGs, which I obtained and provided to her. So now I attach considerable importance to the date, 8 February 2007. That is shortly after the task team, which was purportedly set up to fast-track TRC investigations, was set up. A member of her department was represented therein. So I find it very strange to see how, if this is correct, obviously I don't know if this letter is accurate, but if it is, how the minister could be under such an impression when there has been this task team. The minutes of the first meeting, I think, are attached to my March this year affidavit, and it was clearly the intention to everybody made clear that we need to move now on those investigations. So I find it extraordinary that such a view should be expressed. And also, the minister had to concur with the guidelines which Advocate Pakoli had approved. So again, I find it very strange that there would be no prosecutions when you're setting up. You've got to go through a whole legislative process to have those guidelines approved. You're setting up a task team, people have to attend the meetings, etc., if there are going to be no prosecutions.
And let's turn back to your affidavit. at page 146, and then you have a last sub-paragraph 46.5. And we've dealt with this memo already. This is the memo addressed to the Minister by Pakuli, setting out considerable detail what he construed to be interference with the dealing of TRC matters by other government departments. And he makes that conclusion. That's at page 210, and that's about a week later, after he receives that letter from the minister. That's 15 February. And then you quote the passage that we have already quoted previously. But perhaps if we can go to 220, we can just look at the concluding paragraphs from 5.3, where he writes, "It would appear that there is a general expectation on the part of the Department of Justice and Constitutional Development, SAPS and NEAR, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that." So when you look at these annexes, RCM 13 to RCM 17 that you attached to your 2018 affidavit, I suppose I should put it to you, do these documents, and given the almost total lack of investigations that occurred between 2003 and 2010, does this not point to what one might refer to as unwarranted executive interventions in the TRC cases that were being handled by the NPA?
Madam Chair, I prefer to leave that to Advocate Pakuli, who dealt directly with the Minister, and Dr. Rumahiti, who alleged that the stopping of the Chikane prosecution and therefore a monitoring investigations, that they deal with it. So I don't know. Yeah, I don't know how the Minister saying I was under the impression there amounted to executive interference. It's simply a view that she expressed, which Advocate Pakuli in detail responded to, saying that's not the position. And then, as I said, I don't know what prompted both the police and the DSO in 2003 to elect not to investigate. And I don't know what happened in between, because I was full-time involved in the nuclear case and not dealing with TRC matters. So I'd rather leave this question to be answered by the people who have direct knowledge of that.
Thank you. Well, indeed, both Advocates Pakuli and Ramaiti have testified on these points before the Commission. Then let me ask you for elaboration on what you say in your paragraph 47. These documents speak for themselves and go a long way in explaining why from 2003, the PCLU constantly struggled to have the TRC cases investigated.
This is correct. As I said, I only found those documents many years later. But if you read what's stated in those documents which I attach, that could well be a reason for what happened.
Yes, and certainly it'll be the view of the families that it was not merely a coincidence that you struggled to get investigators for a period of 7 years. That in fact that struggle was intimately connected to these decisions and the views expressed in those documents. They weren't unconnected. Would you agree?
Madam Chair, if you look at the Amnesty Task Team minutes, the first question I raise is when those meetings took place, the issue was not that we need to have indemnity for people who didn't apply for amnesty at the TRC. It was that the two investigative agencies were not investigating, despite the PCLU having identified cases that required investigation. If you look further into those minutes, there's first of all exploring the possibility of preventing people having private prosecutions. Now, it's absolutely fundamental to our legal system that if the NPA declines to prosecute, the person who suffered the harm is entitled to have a prosecution, private prosecution. When it comes to preventing people going to the International Criminal Court, I had met personally the first and second chief prosecutors. They had each told me that the International Court not only relies on state referrals, but also has a mechanism whereby civil society can bring matters to their attention. So the question is, how can you prevent a South African citizen approaching the International Criminal Court when South Africa has ratified an international convention recognizing the International Court and committing itself in domestic legislation to assisting the court? These are all things that point to me that if a decision taken to not to prosecute, there will be no other recourse available. And it's contrary to the law. I mean, if we look at these prominent corruption cases where Freedom Under the Law, Helen Suzman Foundation were able to successfully review several key decisions not to prosecute, and prosecutions had to then be instituted.
Yes, indeed. Well, we know, Mr. McAdam, that the Amnesty Task Team got legal advice, and they were advised that it would be illegal and unconstitutional to try and stop civil litigation and private prosecutions in respect of the TRC cases. But nonetheless, you would agree that this points to the intention behind the posing of those questions?
That is correct. I honestly can't see why they would be so concerned about those matters. Because if it comes to the further indemnity, the President had, I think this was now April 2003, when the President had to address Parliament and put on public record his response to the TRC report. He specifically said he is aware of widespread calls for further amnesties, and he rules that out. So why would his officials then be contemplating a second amnesty process?
Yes, although in the President's speech, he did certainly rule out a further amnesty, which would be unconstitutional, but he did speak of exploring ways to accommodate those who had not applied for amnesty.
Madam Chair, there are pre-existing mechanisms to address that issue. Firstly, any person implicated in a crime can make representations to the NPA not to prosecute, and those are then always assessed on their individual merits. Yes, sometimes you don't, even though the person admits he committed a crime. Sometimes we say no. Secondly, we have the vital tool in the Criminal Procedure Act that anybody who is prepared to testify against the other people who participated in a crime can then testify against those people, and if the court finds that the person was a satisfactory witness, indemnify the person from criminal prosecution.
Noted, thank you. Mr. McAdam, I now want us to move to your 2015 affidavit. That's the affidavit that you made out in the Nkadameng case. The beginning of the affidavit is at page 95, red paginated number 95 of the bundle. It's an affidavit that you attested to on the 6th day of August 2015.
Correct, correct. We have it in front of us.
Oh. And can you just briefly explain why you were required to make out an affidavit in the Nkadiming matter? And just to remind ourselves, Tembi Nkadiming, as she was known in those days, and these days she's known as Tembi Simelane, she brought an application against the NPA, National Commissioner, Minister of Justice, and others for a decision either to make a prosecutorial decision or to refer the matter to an inquest. You can explain how it is that you made out an affidavit in this matter.
She brought a mandamus application against the respondents cited on the covering page of my affidavit, and because I was the prosecutor dealing with TRC cases, I was required to make an affidavit setting out what I had dealt with the matter, and that's why I deposed to it.
Thanks for that clarification. And am I right in saying that this supporting affidavit and the other answering papers were not actually filed because the matter was eventually settled?
I'm not aware of the final resolution of this matter. I'm just trying to see. I see my affidavit was dated the 1st of November 2018, but as a matter of, I see the date on the back page, page 147.
No,
I
sorry,
signed that.
we're on the wrong. No,
We're on the wrong page. Affidavit. Sorry, I apologize. Yeah. I'm trying to see the date on which I did the supporting affidavit. If you'll just bear with me, we're trying to find the date that this affidavit was commissioned.
Page
I can help you. Thanks.
We can't find it. The only reason I want to mention that is that already at the end of May 2015, I had submitted a full report to Advocate Johnson, who was the head of the PCLU at the time, and I had analysed all the evidence. I had dealt with the various scenarios, prosecute people for murders, prosecute somebody else for kidnapping, and I concluded that the safest option was to have a formal inquest before a judge, which corresponded with the relief that was sought by the applicant in the case. So,
thank you. It is important that you do find the affidavit. Can I just check whether you have it? It starts on page 95. The signature page is 105.
May I also look at my own papers? Perhaps I have the copy that is signed and dated, then it will resolve everything. If
yes.
you just bear with me, if I could just page through it.
Although your colleague helping you, can we just ask that your colleague turn to page 95 of the bundle? That's red paginated number 95.
Yes, I see that. I'm just what's important is my affidavit is then signed on the 6th of August 2015, and I am just checking my report and recommendation was already done on the 28th of May 2015. So I don't know. All I know is that at some stage Advocate Johnson approached me and said, on the instructions of either Advocate Abrams or Advocate Jiba, the case has been taken away from me, and subsequently it was given to two advocates in Joburg. But I had done all my work already on the 28th of May 2015.
Noted. All right, let's now deal with this affidavit. And I'm going to try and move through it quickly because there is some repetition, which I will try to avoid. So can I ask you to turn to page 97?
I have it in front of me.
And you then, from paragraph 7 onwards, you deal with your interactions with then divisional head of the detective services of SAPS, Commissioner Lala. Before we get into what you mentioned here, I'm reminded that back in 2003, together with Advocate Pretorius and Advocate Ackerman SC, you attended a meeting with Raymond Lala in order to perhaps ask for investigators or get advice on that question. And that unbeknown to the three of you, that meeting was clandestinely recorded. And subsequently, the three of you were called into NDPP and Guka's office. Firstly, can I check with you, what was the reason for meeting with Lala at that point in time?
I had worked very closely with Commissioner Lala when he was the provincial head of crime intelligence and I was doing political violence cases. What happened is the crime intelligence office in, I think, Limpopo submitted a report which came to my attention alleging that Mrs. Mandela was involved in the murder. There is, if we can just go to my March affidavit, I attached the letter that I wrote to Advocate Lala. So we wanted his assistance on the issue of this intelligence report so it could be taken further. Secondly, I was at that stage assisting the Department of Justice in oppose the review application on the Motherwell bombing case. Now, there was a conflict between the applicants as to what was the motive for killing those policemen. The one version was that they were going to reveal their knowledge of the Craddock Four and other serious matters, but on the other hand, it was alleged no, they had now decided to defect to the ANC, and they had to be killed to prevent them revealing the identities of agents and formers' safe houses. Because that was when the matter was set aside by the Cape Town High Court. Those were the aspects that they found that when amnesty was refused and the TRC did not have proper evidence before it accepted one version and rejected the other. Now, with many of the crime intelligence persons having come from Mkonto with Sizwe, I was hoping that Commissioner Lala would be able to very quickly establish whether, in fact, there was ever any record of that recruitment. So that's why we wanted to meet with him. It was set out in an annex. The letter I wrote to him is an annexure to my March affidavit.
Thank you. And if needs be, we will consult it. But according to Advocate Ackerman, in addition to those specific requests, was there also not a desire to see whether Commissioner Lala could assist with the investigation of the TRC cases, given that the DSO at that time had declined?
He was the head of crime intelligence. He couldn't conduct investigations. That's the responsibility of the detective service. But what I remember very vividly is that this meeting took place a month after the refusal by Advocate Ladaba not to investigate the matters through the DSO. And Advocate Ackerman let off steam. He was very vocal about how bad the DSO were in not doing that. Because, you know, both of us were really seriously affected by that decision. So he just let off steam, believing that this would not go further than the 4 people in the room. And what I remember is that as we were leaving, Advocate Ackerman said, I have to make a decision against the president, which was perfectly correct. The president had been refused amnesty. There were 400 dockets investigated. So obviously we had to see if there was any evidence of him or not. So that was correct. And Mr. Nguka had said specifically that Advocate Ackerman must make the decision in the case involving the president.
Noted. And although he was at that point head of crime intelligence, was there any discussion on whether SAPS could play a role in investigating the TRC cases?
Yes, you'll see that we are asking him to assist us on the intelligence level. Could they verify which of those two versions is correct regarding the purpose for which those policemen were killed? And secondly, the allegation against Mrs. Mandela had been generated in an intelligence report, so obviously letting us see that report and the follow-up material would enable us to determine whether or not that allegation is correct.
Noted. All right. So now we're essentially fast forwarding. If I can draw your attention to paragraph 10, and perhaps this is in the context of acting NDPP in share, asking you to negotiate with SAPS about pointing investigators to the TRC cases. So, for example, at paragraph 10, as a result of Commissioner Lala's advice, I commenced further set of engagements aimed at persuading the DPCI to investigate the matters. You point out that on 25 March 2010, you'd written to the DPCI requesting the instant matter, that of course would be the Nokutula Simelane matter. And you were informed that these investigations could only commence after the conclusion of the 2010 World Cup. Would I be right in saying that not just the Nokutula Simelane matter had to wait for the World Cup to conclude, but all the other TRC matters as well?
That's correct.
Let's move on. If I can ask you to turn to page 99. And at paragraph 14. Now, this is in relation to the Nokutula Simelane matter. You indicate that on an ongoing basis, you were consulted by the investigating officer regarding the conduct of the investigation. It was clear to me that he was encountering difficulties in complying with your instructions. Can I ask which investigating officer this was?
It was Captain Masigela.
Thank you. You then go on to say, at a certain stage, however, he resubmitted the docket together with a statement from the 96 investigating officer, Captain Leask. Now, am I right in saying that once the investigations got going post the World Cup, it was noted that the original docket was missing or could not be found? And I believe that at that point only a duplicate docket was located. Is that correct?
That's correct.
Commissioners, we can refer to the SAPS bundle at page 45. I'll wait for you to find it, Mr. McAdam. There is a letter from yourself to Superintendent Bester dated 25 March 2010.
Yes.
And it's titled Investigation Nokutula Simelane, and it gives the case number, John Foster Plain Square. If I can draw your attention to the second page, the second last paragraph. The NPA was only provided with a duplicate docket. It is only to be anticipated that it may be difficult to locate the original, as this was opened by the Dolavira unit, which closed down 10 years ago. Now, would you agree that, not finding the original docket or the original docket going missing, that this is the sort of thing that happens when a case is left dormant, over a 10-year or more period?
Linked there too is also a lack of continuity, because this started as a De Oliveira investigation, and then, as I recall, 1998, the unit dissolved to address, serious new crime threats. That was they were operating out of the DPP's office in Pretoria and Church Square. When Mr. Nguka set up his human rights TRC unit, everything was then moved to the Maysboard building in Hatfield. Then, when the Scorpions were established, the documents moved to the Promat building in Silverton, and then the documents then came to the VGM. So, unfortunately, this is what happened. But I will say in this matter, by October 2010, we'd found the original docket, and I was able to then write an 11-page instruction to Captain Masigela, identifying all the aspects that needed to be investigated. Madam Chair, I have before me all my letters giving instructions to the investigation to the police. So certainly, once we had that docket, we were doing a lot of investigations. Unfortunately, because Captain Least was said, don't stop further, because this case must go to Captain Holmes and be part of an investigation against General Engelbrecht. A lot of things that he would have done in 96, we could only do in 2010. And also, when Captain Leask had the docket, the TRC process had not unfolded. Now, when the matter went to the TRC, the suspects came out with elaborate explanations as to why they would not have murdered the deceased, and they gave examples of where she had given information leading to the arrest of other people. The security police, had to themselves plant limpet mines at 2 Eskom substations and on a railway line to mislead the ANC into believing that she was still a loyal ANC member, giving instructions to people on the ground to plant those limpet mines. So it took a lot of time for us to do all those investigations, but already by 28th March 2015, I was satisfied that there was enough evidence for me to say we can go for the inquest. I evaluated all the evidence, debated various scenarios. Yes, I did thereafter write to Brigadier Kaba and say that although we're going for the inquest, because I was fully under the impression we were going to have an inquest. There were even discussions with the DPP in Pretoria and Joburg, because they had a direct interest in the matter. The kidnapping started in Joburg. We believed she was killed in a rural area falling under GBP. That I identified a list of further investigations which I told Brigadier Kaba needed to be done before we actually start leading the evidence at the hearing.
Thank you. And if we can proceed in the same affidavit, if I can ask you to jump to red paginated number 102, and I'm going to draw your attention to paragraph 30. So here you point out that in May of 2015, Tembi and Kadamang's application was served on the NPA, and you point out in the third line that had the LRC, that's the Legal Resources Centre, instead of launching this application, if it written to the NPA, it would have been advised that a decision whether to prosecute or not or hold an inquest would be made within a short period of time. I want to put it to you that application did not come out of the blue, but it was preceded by multiple exchanges of correspondence in the preceding years. Would you accept that?
Madam Chair, I know of frequent engagements. I was involved in some of them, but the bottom line is on the 28th of October, proper investigations started and continued right up until the point when the application was lodged. And what happened, the applications filed on 20 May 2015. 28 May 2015, I'd assessed all the evidence and made a recommendation to hold a formal inquest before a judge. So in my view, if the applicants had come to the MPA and said, when are you going to make a decision? Because already I believe that on the 9th of April 2015, Advocate Abrams, then a senior state advocate, had started reading the docket handed to him by the police. And even though I was dealing with foreign bribery, I was helping him because of my historical knowledge. So the process of the MPA reading the docket to make a decision had already started a month before the application was lodged. So in my view, if it would have been more appropriate to come to the MPA, we are concerned all the delays, this is an old case, these are all the prejudices. Can you commit? Because we would have probably said, yes, we will make a decision by the end of May. If the applicant was dissatisfied, she had the perfect right. But the problem is, the application's lodged. Then you have to stop work on the decision to now read the application, had to draft this affidavit. The police also uplifted the docket so that it could be considered by their legal advisors, as the police were a co-respondent in the matter.
Yes, well, it's certainly the version of the Similani family that they had exercised considerable restraint and patience, and that they had permitted the NPA to investigate further for several years, and that the action taken in 2015 was reasonable in the circumstances. Now, I don't wish to refer to the correspondence now, but if needs be, we can return to it. But it is, Commissioners, in Bundle 4 before the Commission. I'm advised by my attorneys that there's at least 12 exchanges between the family's attorneys and the NPA. I accept that not all of them were with you, Advocate McAdam, but I want to put it to you that the application did not come out of the blue because of the preceding correspondence and the fact that the NPA had been placed on terms. And I also want to put it to you that the family acted with some justification in bringing the application at that time, given the lengthy delays in the matter.
Well, Madam Chair, I stand by the point that normally you do not launch a substantial application unless you have put the respondents on terms, because in this matter it would have been quickly resolved with a lot less problems and costs than it was done. Because, I mean, after I wrote the letter to Captain Masakela in October 2011, I had a meeting with Advocate Palmer, who represented the applicant. The applicant was present. I spent a whole day taking Advocate Palmer through that instruction to the police. And he then said to me, he thanks me sincerely for going to all these efforts, despite the fact that this is a problematic case. And after that, I continued constantly contacting the investigator, directing further investigations. Now, I can understand the family is frustrated. They are victims. But what prevented the legal representatives to say, well, is it the best route to go this mandamus route, or should we not come to the NPA and say, what are you now doing? And I agree. If we said, no, you'll have to wait another long period, then you would be 100% right in bringing this application. Yes.
All right. Well, in order to save time, because obviously time is fleeting, we will put up the correspondence, because the correspondence includes a letter of demand, and goes over a period of some years. Let's move on. And perhaps you can turn the page. That'll now be page 103, and let's focus on paragraph 33. And here you deal with the delay in finalizing the investigation. And there are lots of reasons. But I want to highlight 33.3. No investigations were conducted from 1996 until October 2010. Now, from the perspective of the families, they're now familiar why. In that period, there were no investigations. We've traversed that in great detail. We attribute that to the interventions that the executive imposed on the NPA, as well as the conduct of elements within SAPS. Their question, however, or at least the Simelane family question, is the delay between October 2020 and the filing of the application in early, at least in May of 2015. So a period of 4 odd years. Do not accept that a 4-year delay in reaching a decision is not acceptable in the circumstances.
Madam Chair, if you look at all the work the police did between October 2010 and May 2015, that 4-year delay can be justified, because there were a whole range of unfolding investigations, and considerable evidence was gathered. We walked the extra mile on this case. I have all my directives here available to show you all the efforts that the police and I and the missing persons task team did. And there is case law dealing with unreasonable delay, and it says that will be tend on case to case. You can't just have a flat rule, 4 years is out. On this matter, Captain Masekela and I were putting considerable efforts into this matter. Missing persons was involved. We even had a potential breakthrough that in an excavation, a skeleton was found in an area which linked Pretoria to the farm where the deceased was taken. An on-site examination by a Pretoria anthropologist was that the skeleton would be of a female in the age group of the deceased, and there was evidence of a fracture to the jaw. At the time, the area was, when that skeleton would have been there, was when it was a very rural, forested area. But at the time of the excavation, there'd been urban expansion, and is now being graded to become housing. And one of the modus operandis of the security police is take the person to a remote spot, shoot them through the back of the head, and then bury them in a grave. So I thought that the breaking of the jaw is that she had managed to escape and was fleeing for her life, tripped, fell, broke her jaw, lied there until she died. And what we did is we first asked for the facial reconstruction to be done, which would be that you take the skull and compare it to a photograph of the deceased and see whether you can say the skull belongs to the deceased. We also asked the police DNA laboratory to take DNA samples. The report was that they could not obtain sufficient DNA to do a comparison and make either a positive or negative finding. Thereafter, I went to Brigadier Russ, the head of the unit. She agreed that the DNA, that sample would be submitted to a special laboratory in Bosnia, which did all the DNA testings relating to the Yugoslavian genocide. Now, after all those efforts we went to, it did unfortunately show it was not the deceased skeleton we'd found. But I could not simply make all those efforts. It must be emphasized, the remains of the deceased were never found and subjected to a post-mortem report. There's no witnesses to what she had died. There were conflicting versions on the state witnesses as to where and in whose company she was last seen alive. So what we did is, and then we had the version of our suspects saying, no, she was dropped off at the Swaziland border post to go back into the ANC. So what we did is two things. We sat down, Captain Masakela, Missing Persons Task Team, and we mapped out every single location that featured in this whole case. She was kidnapped from the Carlton Centre. She was taken to the Norwood Flats. She was taken to the farm in the Northern District. A single witness claimed she was seen after the farm in a boot of a car still alive at a crossroad near Potch. So we mapped out all of those areas, and the missing persons team went to each and every one. They checked all the mortuaries, looking to see is there an unidentified corpse that could match the deceased. But we didn't stop there. We said, let us find out at this time, 1983, where were the safe houses that were used by these people. So we checked them out. The one case, it was said there was a plot on this southern outskirts of Joburg. When we went there, it was now a shopping mall. One witness said that a deceased member had told him she had been shot dead and buried in a safe house in Rustenburg. A lot of efforts went into trying to find that safe house. The missing persons team went to the farm. When they arrived there, it was midsummer. The grass was knee-high. They said it's impossible to put their probes. We'll have to wait till winter. And then we can do our work. They went back in winter. They said the ground's too hard. We can't get our probes in. They said we'll have to wait till the first rain so the soil's soft, but the grass hasn't grown, which they did. But what they said is they checked all the spots that were prominent in the case, a dam, a shed that the deceased was kept in, a house. They couldn't find anything there, but they said this farm is so vast that unless somebody who is involved in a killing comes forward and points out, they can't take it any further. A key factor relied on by the suspects was that as a result of her information, they were able to arrest a group of MK operatives. We did a lot of work going into who those people were. We found extensive documentation, security, police reports of their interrogations, etc. And at the end of the day, I was firmly convinced I could prove that the information came not from Nokatula Simelane, but from another source who was based in Bethel in the Mpumalanga. On the planting of limpet mines at the railway line and the Randburg substations, we could not find any evidence relating to that railway line. After an exhaustive effort, looking for the police docket, looking at bomb squad, we eventually got Eskom reports on their examination of those two substations, and then we found that the author of that report was in an old age home in Kimberley. So Captain Masakela went there, he interviewed him. A lot of efforts were, when this docket was taken from lease in 1996, that wasn't a cover-up. Mike Holmes, the investigating officer in the Eugene de Kock case, was now busy with an investigation into Croppies Engelbrecht, and they believed that the Nokatula Simelane case should be part and parcel of that investigation. And I went to a lot, unfortunately, Mike Holmes died in either 2002 or 2003 from cancer. I and Captain Masakela went to a lot of effort to try and find his docket on the subsequent investigation. We interviewed colleagues that had worked with Mike at the time, and we were unable to find that further investigation. What I did locate was the report which Dr. Romahiti submitted to Mr. Ngmuka, setting out the investigations that were conducted. Now, the Nokatula Simelane case was not listed as one of the cases submitted by Captain Holmes to the DPP. There's nothing suspicious about that. If you have a target, General Engelbrecht, you pull up all the cases that he could possibly involve, but then you focus on the ones where you believe you have good evidence, and you don't focus on the others. Now, what I believe is that Captain Holmes had achieved considerable success against de Kock by getting the people who'd killed on his orders to turn state witness. So what I suspect happened here is that Holmes believed that Pretorius and Coetzee may well follow the route of the 204 witnesses, and obviously, if that was the case, then it would be a good investigation.
Thank you, Mr. McAdam. We really do need to move on. We don't doubt the lengths that you have gone into. I'll simply put the perspective of the families to you. I want to move to another document, and that's at page 111 of the bundle. I'll just wait for you to get there. Now, this is a ministerial memorandum. It's from Advocate Abrams, who at that time was the NDPP. It's addressed to the then Minister of Justice, Masutu. It's titled A Memo to the Minister.
I have it before me.
Thank you. Commissioner?
No, I say it's Masuta.
Masuta, thank you for the correction. So it's titled Report on Investigations and Prosecutions Emanating from the TRC. It's dated 15 July 2015. It's quite a long memo. We're not going to have time to go through it in great detail, but can I refer you to page 120? The preceding pages gives a detailed account as to why the TRC cases were not attended to and addressed in the past. And paragraph 3.17 caught my eye, and because we haven't, I'm trying to focus on matters we haven't dealt with previously. It reads, SAPS notified the ANDPP, Advocate Mshere SC, that it would not continue to investigate TRC cases pending the outcome of the Ginwala Commission. Now, can I ask, would there be any basis not to investigate the TRC cases, murders, kidnappings, and the like, pending the outcome of a commission looking into the suitability of an NDPP to hold office?
No, not at all. None of the matters that we wanted to investigate would depend on the credibility or actions of Advocate Pakoli, because you now had a new NDPP who had not clashed with the other departments in the task team.
Yes. And in the same vein, let's look at the next paragraph, 318. It says a group of victims brought in action in the High Court to have the TRC guidelines set aside on the basis that they had introduced a second amnesty process and hence unconstitutional. This application was successful and further delayed the investigation of TRC cases because the then Minister Mabandla and NDPP Mshe SC first attempted to take the judgment on appeal. And the same question, why would a decision to take a judgment on appeal, setting aside the guidelines, why would that delay the investigation of TRC cases?
I could be totally mistaken on this point, but I believe at some stage Advocate Mshe was given some legal advice that continuing with the investigations would be problematic for the appeal. But that's not something I can categorically say. It's merely what may have happened. But again, the appeal, the only issue where it would be relevant is if there's a queue of people all wanting to make disclosures in terms of the guidelines, and now, until the court rules that the guidelines are valid, that would not apply. But there were no such cases.
Let's turn to page 131. There's a heading there, paragraph 6, matters of current concerns. And let's turn to paragraph 6.2 at the bottom of the page. NDPP Abrams writes, unfortunately, the quality of investigations is very poor and is having a negative impact on being able to finalize the cases quickly. Would you agree with that conclusion?
No, Chair, I don't know how he could make this as a general statement, because as I said, from 2014 up until June 2015, he was on a daily basis reading these dockets. But I can confirm in certain cases we were experiencing difficulties which we put down to inexperience, a lack of historical knowledge, and also these people are doing these cases over and above all the other cases that they must investigate. But if you look at the Nokatula Simelane case, the investigating officer, with the support from myself and the missing persons task team, did a lot of really difficult, complex investigations. So I don't know if it would be unfair to individual investigators to taint everyone with the same brush.
And if we turn the page to 132, he gives some examples. I want to focus on 6.2.2. In the Heidelberg Tavern and St. James Church cases, the DPCR claimed that the police dockets and court records could not be located, although it has now been established that for many years the relevant material was in fact in the possession of the DPCI. And you will recall that those two massacres were listed in the information note of Assistant Commissioner Jacobs as two of the cases to be taken up. And now we see in a memo of the then NDPP saying that the DPCR claimed they couldn't locate the police dockets, even though it was in fact in their possession. Isn't that somewhat shocking?
Madam Chair, it's a breakdown of continuity, because these two dockets, the St. James Church massacre, were first investigated by the ordinary police in Cape Town as part of the APLA investigations. And what had happened is the APLA investigations, which all went the way of amnesty granted or persons convicted, at some stage would have been filed with the Crimes Against the State unit. I don't know when that process took place. Then Captain Nell was appointed to investigate. He was unable to find them, resulting in he and I going to Cape Town, searching the registrar's office and contacting Mike Barclays in the region to go around the police stations looking for them. So again, when you have lack of continuity, gaps, etc., unfortunately, this type of thing does happen. But, you know, I don't know as well how good the CAT's record keeping was, if there was an easy computer program that would have accurately all the cases that have been registered or not.
Thank you. And then let me get your response to paras 6.3 and 6.6. I'll start with 6.3. The failure for the matter to be investigated from 2003 until 2011 has prevented prosecutions being instituted in cases that could possibly have resulted in convictions. This is because by the time the cases were eventually investigated, the suspects and/or witnesses were already deceased. And in brackets, he puts up examples of Craddock 4 and Petro 3. And then he says this astonishing statement in 6.6 on the next page. It is only to be expected that once the decisions are publicly announced and the failure to investigate exposed, that allegations will be made that government deliberately waited for all the witnesses and accused to die before giving attention to the cases. So it appears that within the NPA, that was a real fear that this is the kind of discussion or allegation that will be made in public against the government.
Correct. I was actually raising this issue when I had engagements with my superiors to say why it's important. Because if we don't do that, there will be a strong basis for an inference that it was done deliberately to let everybody die so that there would be no prosecutions. That's why I said it's important. I think if you look at all my engagements trying to get these matters investigated, etc., I was doing my utmost to try and get them done. And I think what I said on this point is true. And this is what I was doing to say, please guys, let's do it now. This is the consequence if we don't. And it's true. I mean, the PEPCO 3 matter, the two leading culprits who carried out the kidnapping and the murder all died before, in 2010, we could consider prosecuting. The same thing in Craddock 4. Key role players were already dead in 2010. And if we go on, the Nokatula Simelane case as well, people that were mentioned by other witnesses as being able to confirm one version and the other were dead. So you couldn't follow it up. The person who claimed to know about her being killed in a safe house was also dead. So we couldn't get him to take us to this area, point it out, and see if we could exhume the body.
Indeed. Mr. McAdam, let's now turn to the affidavit that you have made out before this commission. It starts at page 226 of the bundle. And before I forget, you've helpfully made reference to various notes and directives that are in your possession. Can I ask, are they currently part of your bundle? And if they're not, would you be willing to hand them up to the Commission?
The directions that I gave on the Nokatula Simelane matter, is that what you're referring to? Yes. I have no objection. I'll give them to the State Attorney and she can then submit it to the Commission, just advising the NPA that we are handing these dockets over. When the former National Director, Advocate Batoy, did write a letter giving me permission, instructing the NPA to make available to me all documentation that I needed to place before the Commission. And in this Nokatula Simelane, if we can't obviously go through these things now, it'll take forever. But if somebody sits down and reads them, it gives you a very good picture of the challenges, the difficulties. But despite all these difficulties, we don't throw in the towel. We kept pushing and plugging.
Just on the on those documents, we should take note that the Nokatula Simelane case is still a live case. It has been delayed since 2016 for various reasons I won't go into, but the trial itself actually has not started. So I don't think that those documents should be made public. I think they should be given to the Commission for the Commission and the parties to look at, but they should not be posted on the website.
I agree wholeheartedly. I wasn't aware that the case is still pending. These documents could be used to further delay the proceedings, opening the door to legal challenges there. So I don't know if the Commission has the power to place documents under seal. That would mean they may not be viewed except by the Commission and the legal representatives. But if there is a way in which the disclosure to the public and to the suspects could be protected, I would not. But obviously I would have really concerns if it goes public.
Yes. Yes, indeed. So we will, with the chairperson's indulgence, confer with the evidence leaders to see whether that is possible and that they can be protected under seal and not disclosed further. And I think,
if I may just add, I'm a retired official, so any matter involving these documents should be brought to the attention of the MPA, because they are the people that are going to be directly affected. So I would urge, what I would do from my side, the office manager of the NDPP is the nodal point for this inquiry. I can set up a meet with him and tell him so he can alert the people as to this matter.
yes, indeed. And I'm sure our colleagues from representing the NPA can also make inquiries. We certainly don't want to jeopardize the case in any way. All right, thanks for that helpful suggestion. If we can turn to your current statement, that's from page 226. And again, I'm going to try and avoid repetition where I can. So let's jump some pages.
21, Mr. Vani.
That's correct. Yes, indeed. The first few pages are the index. So it does start at page 231. Thanks for that correction, Chair. And Mr. McAdam, can I ask you to jump several pages to page 9 of the affidavit? That's 240 of the bundle. I just want to point to 31.3. This is an exchange between Advocate Ackerman and Attorney Wagenaar. And you write as follows: Mr. Ackerman did in fact meet Mr. Wagenaar and advised him accordingly. Upon his return from the meeting with Mr. Wagenaar, Mr. Ackerman informed me that Wagenaar had stated that any prosecution of his clients would lead to the prosecution of the leadership of the ANC who had been refused amnesty. Did you regard that at that time as an implied threat?
Correct. It was taken forward after Mr. Wagenaar represented Messrs. Flock and van der Merwe at the plea agreement involving Reverend Chikane. Thereafter, acting for AfriForum, he then wrote to Advocate Pekoli saying that as a result of the plea agreement, the ANC must be prosecuted, and he's then identified this Messina landmine case as the case to be investigated, and he also said that as a result of the conduct of Advocate Ackerman in doing the plea agreement, he will be the ideal place to issue subpoenas in terms of Section 205 and to make people cooperating accomplice witnesses in terms of Section 204. I do have the letter, it can be made available if required.
Yes, I think we would like that letter, and I don't think there's any issue in putting that up. So, yes, so if you could make that available, we would, excuse me, we would be grateful. And on that score, Mr. McAdam, the families will be putting it to the commission, or making a submission eventually, that this was in fact a strategy that Mr. Wagenaar, his clients, former Commissioner van der Merwe and his organization, together with individuals within the SAPS, this was a strategy that they adopted in order to instill fear by those occupying leadership positions in government to clamp down on the TRC cases. What is your response to that?
That's correct. It is documented. I can also make available a press statement that was released by Messrs. Vlok and van der Merwe after they were convicted in the plea and sentence agreement. I also have available a letter that they wrote to Reverend Chikani in 2004 after Advocate Ackerman was prevented from proceeding with the original prosecution in the Chikani matter.
Yes, please do. We want to check. We might have those documents, but I'm not sure. So if you could make them available, we would be grateful. All right, I'm just skimming through the balance of your latest affidavit. And in the interest of time, I think we have covered much of it. Perhaps I can ask you to jump to page 23 of your affidavit. It's at paginated page 254. And we will actually need to go back a couple of paragraphs. If we can turn to the previous page, 253. This is under the heading NDPP and Ms. Shamila Batoy's term. Although you do go back into history. So, for example, you speak of the nodal points, your appointment as an acting special director, that you handled and oversaw TRC matters until September 2021, that you commenced an audit of all cases. That's in 84. And if we turn to para 85, in respect to the TRC cases, Brigadier Kaba of the CATS unit provided me with details of approximately 30 cases under investigation, which included some of those I'd referred to the DPCI in 2010. I established that only 4 cases were receiving dedicated attention from a prosecutor. Shortly thereafter, Brigadier Kaba's Commander General Adwaba requested me to appoint prosecutors for all cases. And then we turn to paragraph 86. Reviewing the dockets, I had concerns regarding the quality and pace of the investigations, which in part I attribute to the absence of any research capability and other resource challenges. As stated above, some of the cases referred to in 2010 were still not finalized. Then you refer to other communications. So this is now you are speaking in 2019, and you make mention of the fact that some of the cases which had been referred to the DPCI in 2010 were still not finalized. That's nearly 10 years later.
That's correct.
Would you agree?
Sorry, I interrupted you.
Sorry.
I apologize.
No problem. Would you agree that that lapse between 2010 and 2019 is somewhat shocking and unacceptable, given that suspects and witnesses would have been dying through those years?
As I said, I deal with the issue of the absence of a research capability, resource constraints as being a key reason. That is why you'll see in my email to Advocate Mzanyati, I said we need to address this issue of investigations by the DPCI, because fair enough, I pointed to some investigators under very difficult circumstances doing very good work, but we had lots of examples of, in my view, substandard work. For example, in the PEPCO 3 matter, what had happened is I asked Brigadier Kaba for the list of cases, but then he also brought in some of the dockets to go see how far they were, to decide are they matters that simply require decisions. They can go to a prosecutor who can deal with them in between his or her court commitments, or at an early stage, and then you need a prosecutor who's not in court who can work full time. And if I can give you some examples, the PEPCO 3 case was written up as fully investigated. It must just go to the DPP. But then the investigating officers, the victims are unknown and have never been contacted. Now, in that case, the victims were the key witnesses in the case. They had to testify to the fact that their husbands disappeared after going to the then Port Elizabeth airport, believing they were meeting a member of the British consulate. So how can you say it's fully investigated if you've never contacted the victims? I'd also, in that matter, I think it's in the letter in 2010, raised the necessity to follow up certain allegations which you'd have to work through the victims, that Mrs. Harsher had filed a second statement saying that she'd been informed by the head of the murder and robbery unit that her husband had been killed in a necklacing in Soweto. Now, how do you follow up that allegation if you've had no contact with the victims? And it goes on, look, in the St. James and the Heidelberg, nobody who was convicted implicated the suspect. He wasn't implicated in the amnesty applications. His involvement commenced allegedly having taken part in radio interviews where he had claimed responsibility for the 2 attacks. And in 2010, I said, you have the necessity to get those recordings and see if they confirm what is alleged. And, and then in May 2019, that aspect has not been addressed. And then also what I found, there are 30 cases, there was an unfair allocation of workload. Captain Nell was carrying no less than 10 cases in every single province except the Northern Cape. Constable Ubisi was on her own carrying 4 cases, including the very complicated case of Adrian Mbambu. On the other hand, you've got people at the rank of colonel doing only 1 investigation. And so it goes on. That's why I said we now, from the MPA, going to put as much resources as possible into the matter, but we're never going to get anywhere if the issue with investigations is not addressed. And these were the efforts that I took. In January 2020, Advocate Patoy and I met with General Labia, expressed our concerns, and then he agreed with us that the way to go forward is he must now appoint 40 experienced retired police officers who can work full-time on the matters. And it goes...
Sorry, carry on.
No, and on the research capability as well, with these TRC cases, before you take one step forward, you've got to gather all the previous evidence to see who featured, are people being consistent in their statements that they make at various times, are other people appearing. They had no research capability at all. And the proper and where we did make progress in my cases was when in 2002 I got permission to hire two former TRC researchers, and they did a lot of very good work for me. I couldn't have drawn up that list identifying the cases that we wanted to prioritize for prosecution if it hadn't been for their contribution.
Thank you, Mr. McAdam. Chairperson, I see it's just gone 1 p.m. There's been appropriate time for the lunch adjournment.
Chair,
Yes.
may we inquire whether Mr. Varney is close to the end? He's been examining for more than a day. We still
Yeah.
have the evidence leaders who've got to
Mr.
ask
Vani,
questions and
for how long are you
re-examination.
going to be cross-examining Advocate McAdams? How long do you still have to go?
Chairperson, we are approaching the finishing line, but we estimate that we would still need around 30 to 40 minutes
Yes,
to wrap up.
yes.
We do apologize. We did suggest to the evidence leaders that we needed 2 days with Advocate McAdam, although at that time we were unaware that there was going to be another application to cross, which only came in recently.
Chair, it's quite important we finish Mr. McAdam's cross-examination today. And our learned friend has had sufficient opportunity. We don't mind 30 more minutes, but if we can keep to
Yes.
that.
No, Advocate Ban, I think we will finish Advocate McAdam's cross-examination today.
Thank you, Chair.
Yeah. We have Mr. Similane, who intended to cross-examine, who has since withdrawn from such cross-examination.
Yes.
We are adjourned until 2 o'clock.
Thank you, Chair.
Mr. Chair, please.
Are you well settled, Advocate Macadam?
Correct, Madam Chair.
Thank you. Mr. Vani?
Chairperson, we will try to speed things up, but we do wish to place on record that Mr. McAdam is a key witness. As mentioned earlier, we had requested 2 days with him. Most of the documents that we have put up were not put up in the evidence in chief. And given the fact-finding mandate of this commission, we are obliged to go through them meticulously. We, of course, were only aware of the application by SAPS last Friday. They were granted permission on Monday, so there were intervening factors as well. Having said that, we will proceed as quickly as we can, but we wish our rights to be respected in regard to putting the necessary facts to Mr. McAdam for his answers, and we hope that the Commission will give us the necessary latitude.
Chair, the Commission, in our view, has given Mr. Varney a lot of latitude. I speak subject to correction, but initially he wanted a full day for his cross-examination, which he's had and more. The further observation is what's put as a question is often just to elicit opinion evidence after a long statement, and that's really not the purpose of cross-examination. If you can stick to putting facts that concern this witness, I'm sure we'll go a lot faster.
Mr. Bana, you can't tell your colleague how to cross-examine.
Yes, but what we can do is to say that there's more than sufficient opportunity that has been given. If
Yes.
it finishes in the 30 minutes, that's fine.
Yeah.
But in our view, that one also has to respect the rights of the witness and the other parties here.
Yes, yes.
Thank you, Chair.
Chairperson, I don't believe that intervention warrants a response. May I proceed?
Yes, you may proceed.
Thank you. Mr. McAdam, I trust that you still have the stamina that you've demonstrated the last 1.5 days. We're now going to move to a different topic. And to assist you and the commissioners, I'm looking at page 3 of the application to cross-examine you. And at the bottom of that page, you'll see the heading, Advocate McAdam's knowledge about the disappearance of the Craddock 4 docket. Now, there is a dispute that has arisen between you and former acting NDPP Advocate Sheba. And I want to give you a summary of the evidence that you provided in your 2021 affidavit in the Craddock 4 application to compel a decision. Your affidavit, incidentally, is at page 462 of the bundle. But a paragraph, at least at page 460, in the Kalata founding affidavit, there is a summary of what you said. I'm going to read that summary to you, and you can advise me whether it is accurate or not. So I'm on page 460. I'll start at paragraph 328 under the heading, The Missing Craddock 4 Docket. McAdam filed an affidavit dated 24 May 2021 as part of the NPA's Rule 53 record in the matter of Kalata and others versus NDPP and others, a copy of which is annexed. In this affidavit, he indicated that during April 2013, while he was Deputy Director of the PCLU and Abrams was the acting head, they received a request for information about the Craddock 4 case from Ms. Lepenka, who was the personal assistant to acting NDPP and Advocate Jiba. Abrams responded to the request. Shortly thereafter, McAdam was asked to hand over the investigation docket with that number to the office of the acting NDPP, which he did. Then just the next paragraph, 329. McAdam then avers that at a certain stage, without disclosing a date, that Advocate Pretorius, then acting head of the PCLU, asked him for the Craddock 4 docket, and he advised Pretorius that it had been uplifted from our office and was missing. McAdam did not disclose why Pretorius was seeking the docket. This exchange must have happened between 2016, when McAdam returned to his normal duties after working on foreign bribery cases, and April 2019, when he assumed the position of acting head of the PCLU. Mr. McAdam, does that roughly sum up the situation in relation to that docket?
Madam Chair, since I saw the affidavit filed by Advocate Jiba before this inquiry, I have done considerable work on the matter, and I can, if I'm permitted, very succinctly explain the actual process that unfolded. I think that will save time, and we'll be talking on direct facts, because I'm in a better position to give this information than I was in May 2019 when I deposed to that affidavit. The Craddock 4 case... Mr. McAdam, before you do so, and for the benefit of the Commission, I think we should just put up the brief version of Advocate Jiba so that the dispute is familiar to everybody. So with your indulgence, I'll just do so quickly, and then you're at liberty to give a full account. I'm going to draw your attention to Advocate Jiba's affidavit before this Commission, and that's at page 465 of this bundle. That's her affidavit, which is dated the 9th of March 2026. And I will just jump straight to where she deals with this. This is on paginate at page 467. And to cut to the chase, I'll just read into the record paragraph 11. With regard to the alleged Craddock 4 missing docket, I never tasked anyone to go and collect a docket from PCLU. Neither did I receive the said docket from the PCLU. I find it strange that Chris McAdam remembers that a person from ANDPP office came to take the docket but does not know who that person is, something that is very important. I'm not going to make the rest. She does claim that what you said in your 2021 affidavit is false. She also attaches correspondence, and just to keep things short, correspondence doesn't reflect that a docket was collected or taken to her office. Now that we've set out the dispute, you may proceed. Thank you, Madam Chair. The Craddock 4 docket was one that I directed be investigated in 2010. In September 2012, the investigation was complete. I then compiled a report dealing with all my reasons as to why, on the available evidence, I was of the view that we could not institute a successful prosecution. That was submitted to the Director of Prosecutions Eastern Cape, at that stage Advocate Mashlati, Senior Counsel. After he had studied my report, together with the assistance of his advocate who had been the junior counsel in the reopened Ganiwe inquest, he wrote back to me advancing all the reasons why he agreed with my recommendation. In terms of the NPA policy that prevailed at that time, the National Director was required to confirm any decision to prosecute or not to prosecute before it's implemented. And specifically in this case, Advocate Jiba had been appointed as an acting National Director because the permanently appointed National Director, Advocate Simelane, was on special leave. Now, I met with Advocate Similani shortly after he was appointed. He told me the investigations must proceed, but he agrees with the policy that has been adopted by all the national directors since Mr. Nguka's time, that I should not make any final decisions before I've submitted the material to him and he's assessed them. So what I did is, once I had the director's report supporting me, both were submitted to Dr. Ramahiti, the Deputy National and also Senior Counsel, with a request that he place the material before Advocate Similani if he agreed with our assessments. After Dr. Ramahiti had assessed the material, he then submitted a report to Advocate Similani supporting our view, confirming that it was also his view, and asking Advocate Similani to indicate whether he agreed or not. What happened is Advocate Similani was then placed on special leave because of the SCA finding about fitness to hold office. So the signed memo from Advocate Similani never came back. When Advocate Jiba was acting as the National Director in his place, I then wrote to Dr. Ramahiti saying that there is now delay. The police were constantly asking me what the position is, because one of the concerns is there was an allegation against the General Hankel in crime intelligence, and as a result of that allegation, he had been removed from his post. Now, on the 17th of September 2012, Dr. Ramahiti wrote to Advocate Jiba, attaching the report, setting out his views, and the final text on the last page of his memo was decision confirmed or not confirmed, Advocate Jiba, Acting National Director of Prosecutions. That internal memorandum was dated 17th of September 2012, and on the same day it was stamped by Advocate Jiba's office as having been received on exactly the same date. However, what happened is no response was received from Advocate Jiba's office, resulting in whether she agreed or not. This resulted in me sending several emails to Dr. Ramahiti querying the delay, and he also copied me on emails where he'd instructed his PA to take up with Advocate Jiba's office where the delay was. The piece kept coming to my office complaining, because I was now getting frustrated. We were sending all these reminders, nothing was happening. I then wrote to the police and said, I recommend that General de Mutt take this directly up, because I have followed protocol querying through my Deputy National, and that has failed to produce results. When Advocate Abrams was appointed as the acting head of the PCLU, I then went to him and I said, here are all the reports, and the final report is that of Dr. Ramahiti, 17 September 2012. It remains unanswered. Can you first read our reports and tell me whether you agree or not? Because as the acting director, he could himself say, no, I disagree, do further investigations, whatever. So he indicated to me, no, he did agree. He will now submit that letter back to Advocate Jiba's office. Now, the same internal memo, date stamped 17 September 2012, came back now, stamped 26 April 2013. On the very same day, Ms. Lapinka, Advocate Jiba's PA, wrote to Advocate Abrams saying, please give the following information to Advocate Jiba so she can apply her mind. If you see the issues that were raised in that letter to Advocate Abrams, it was coming directly out of my report. This resulted in thereafter Advocate Abrams again submitting a second report which answered all those queries, but again, nothing transpired, nothing heard from Advocate Jiba. Now, I was in my monthly report to the head of the PCRU reporting this matter is outstanding pending Advocate Jeeba's decision. That was done every month. Still no response, although now all the answers had been supplied. Now, I was extremely busy at that stage, in and out the office. The reason why I was taken to foreign bribery in 2014, I'd already had to start working on that in 2013. Now, I cannot recall whether it was Advocate Abrams or Ms. Swart, our admin officer, but one of the two informed me that the docket was now required by the Office of the NDPP. I did not regard this as suspicious because if Advocate Jeeba simply agreed with us, she could have signed that memo and sent it back to us, which didn't happen. So the only reason is that she has a problem. That's the only plausible explanation. And I then would have most likely, and again I can't remember, given the docket to Ms. Swart, our admin officer, to deliver. Again, nothing suspicious, because the previous year when Advocate Similani was the national director, I had declined to prosecute in a very high-profile matter. The complainant asked Advocate Similani to review my decision. The docket was called for. After a period of time, I received a letter from Advocate Similani. He agreed with my decision, and the docket was returned to me. So there was nothing suspicious, and I continued to, on a monthly basis, report that the matter is outstanding, pending Advocate Jeeba's decision, right up until Advocate Abrams took over from me as the dedicated prosecutor on TRC matters. In January 2015, I sent Advocate Abrams an email in which I said, the matter is still outstanding on Jeeba's side. The DPP and I have done everything we had. Our decision has been supported by Dr. Ramahiti. So I gave it to him then, 2015. You will see he becomes the national director in June 2015. In his memo to the minister, which is before the court, on the Jeeba matter, he reflects that it is still outstanding on the side of Advocate Jeeba, and the national director must now decide whether to confirm that decision or not. Now, sorry, we must go backwards. Sorry, I apologize for this. As that when Mr. Nkosana was the national director, this would have been now 2014 and up to May 2015. In April 2015, he called me into his office because he wanted an update on the foreign bribery matters. I did so. He then asked me about the TRC matters. I told him, capacity constraints, delays in investigations, and I specifically drew his attention to the fact that now Advocate Jeeba's decision had been outstanding since 2012, and we're now in 2015. He asked me to then give him all the reports on the matter, which I did. They were emailed to him. He thanked me for his reports, but this was shortly before he resigned, so he didn't take it up. This is where Advocate Abrams comes in. His memo 1 month after being in office reflects outstanding that the decision of myself and the DPP still needs to be confirmed. Now, he had two options. He's the national director. He was the person who was giving Advocate Jeeba all the information already in 2013 as the acting director. He was thereafter responsible on a monthly basis to report on what's going on with these cases. So he knew full well what was going on. Now, he said the national director must still confirm. He could do it two ways. He could do it himself, because he's now seized with the matter, and then call on Advocate Jeeba to give him a report saying what she had done. Or he could go to Advocate Jeeba and say, look, this was referred to you in 2012. I authorize you to deal with this yourself, because the MPA Act enables the National Director to refer some of his responsibilities to a Deputy National Director. But I would expect then he would say to Advocate Jiba that she must advise him of what her decision is. So there were those two options available to him. As I said, when Advocate Abrams became the National Director, Dr. Bukhar was appointed to deal with the TRC cases. In her monthly report to Advocate Johnson, she wrote specifically, Jiba's decision is outstanding. The NDPP must take this up with her. What happened is in October 2015, Advocate Johnson was replaced by Dr. Pretorius. Advocate Bukhar wrote to Dr. Pretorius and again said the issue of Jiba's decision remains outstanding. Now, what happened is, at a certain stage, I cannot recall, but when it was in Advocate Dr. Pretorius's domain as acting head, he did come to me asking about the Craddock 4 matter, and I informed him of what had happened. If I remember correctly, I even gave him the reports that had been referred to Advocate Jiba in 2012 and the correspondence of 2013. I said, please take this matter up directly with the National Director and the Advocate Jiba. I heard nothing further from Advocate Pretorius at all on this matter until in 2019, shortly before I was appointing appointed as the acting head, that I was informed by the police that the matter was still outstanding pending Advocate Jiba's review, but now the docket could not be located. Could I please help? So what I did is I then contacted Advocate Mzinyati, who had replaced Advocate Jiba, and I said to him, this is the situation. Can he make a thorough and complete search of all the office premises that were used by Advocate Jiba in all her capacities, acting National Director, etc., and let us see if we can find the missing docket. After a search, he said they could not locate the docket. In my view, there was virtually nothing in that docket which could not be easily reconstructed. So I said, instead of running around looking, let's reconstruct it, which did take place. I'm sure Mr. Varney will want to cross-examine me on evidence led by a Colonel Makua at the reopened Ganiwe inquest, which is running at present in the High Court in the Eastern Cape. So perhaps I'll deal with it separately when he cross-examines. And then what I found out as well, at no stage was that memo of 2012 ever signed off. So I said, through no fault of the family, this matter must be looked at completely afresh, because 7 years had passed since I had made my recommendation. New facts could be available, evidence that I didn't have mine. So I said the whole matter needs to be investigated properly again to see if at this stage there is a basis for a solid prosecution. And that is why the matter was referred to the DPP Eastern Cape, and the DPP said, I am appointing Advocate Henning. He worked on the case at the inquest. He has by far the best knowledge on that Craddock 4 case than anybody in the MPA. And those arrangements were made. But I'd like to deal with that separately when we deal with the Colonel Makua issue, if that is permissible. Everything
Thank you
I
for
say
that
is backed up by documents, everything I say.
Thank you. Are those documents part of the bundle? If not, can we also request that you make those available?
Certainly, Madam Chair. I'm more than willing to do so. In anticipation of this being raised, we have made copies of the documents already for all the parties.
Thank you. I'd be grateful if a copy could be furnished to the family's attorneys. Obviously, we're not in a position to study them now, and time doesn't permit it. So, Mr. McAdam, the docket is uplifted from the PCLU in 2013. As I understand it, Ms. Swartz hands it over. And then, as far as you're aware, it's never seen again. And then the docket is reconstructed in 2019. I understand that the family's investigator, Brigadier Marion, also assisted with that reconstruction. But from the family's perspective, the docket being last seen in 2013 and then having to be reconstructed 6 years later, do you accept that is a completely unacceptable state of affairs?
I do. Advocate Jiba was provided with a very detailed motivation by myself. It was supported by the DPP Eastern Cape. He didn't just say, I agree. He wrote about 2 pages giving all the reasons why he agreed, how he'd verified with many of the facts that are stated there and corresponded with Advocate Henning's assessment because he had been the junior counsel in the matter. We had the support of Dr. Ramahiti, and all that had to happen is Advocate Jiba say, I don't agree, and like was done with Nokatu Somamani, take the case away from me, give it to other advocates, let them read it. None of that happened, and also from my side and from Dr. Bukau, who followed up after, on a monthly basis we were reporting. So it was the duty of the acting head of the PCLU at those times to take this up directly with Advocate Jiba and Advocate Abrams. Abrams admitted in his July memo to the Minister that the NDPP had to still confirm those decisions. So my view, it is totally unacceptable. You have reports, you either agree or you disagree. And if you say, I disagree, you take the necessary steps. The same thing, if there had been a prompt response, perhaps the docket would not have been misplaced. Or if it had, it could have been quickly found because we would have looked for it in, say, 2014 and not in May 2019. And again, the docket never permanently disappeared. Shortly before my retirement, I was in the document center looking for old documents relating to another matter, and there, lo and behold, there was a docket. And once that was brought to once I realized it's the credit for docket, I then arranged with the document center to remove those files and store them separately so they wouldn't get mixed up with all the other material that was being stored there. The DPP Eastern Cape was immediately alerted to the fact that I'd found the dockets. After I retired, Advocate Trish Metzger had been appointed to oversee the TRC cases. She contacted me, and I went to the document center. I pointed out all the documents there. They were exactly as they had been packed when I found them towards the end of 2019.
Well, it does suggest, Mr. McAdam, that if it were that easy to find in the archives, that the initial searches were not very serious searches.
No, there was a thorough investigation, but none of us anticipated that it would be sent to archives. You only archive material once it's finally disposed of. If it's active, you keep it in your offices. And there was a thorough, I have no, because it took time before Advocate Mzimyati told me they couldn't find it. I know the people who did the search, very experienced, competent admin officers. And we were taken aback. How did this docket suddenly end up in the document section, which is only for old, finalized matters? You would still, if you make decisions, you would still keep your dockets in your own office space for, say, 3-4 years, because people could always come with queries and parliamentary questions, etc. So I don't blame the people and accuse them of doing a superficial search. And neither I nor anybody else ever thought that they would end up in the document centre.
And can I ask, between 2013 and 2016, why was there no attempt to retrieve the docket from Advocate Jiba's office?
We were saying, and it was done on a monthly basis, take up with Jiba, what is her decision? We wanted that because that will determine the course of how you deal with the docket. So it wouldn't help taking the docket before we had the decision, unless the police came to me and said, look, there is new evidence, we need that evidence to go into the file, then that would be a different position. But my view is it had been made available as per request, and on a monthly basis. Look, I don't know what Advocate Abrams did when he was the senior state advocate, but in my time it was reported monthly. I was able to locate the consolidated PCLU report for April 2014, which was submitted to the component in the corporate services which monitors performance on the part of prosecution units in order to report to EXCO, and there it was again listed as outstanding pending her decision.
All right, let's then move to the topic that you have anticipated, so that you have an opportunity to respond. And as you indicated, this deals with the evidence given at the Craddock 4 inquest earlier this year, in March 2026, when some of the investigating officers, including Masagela and Makua, testified before the inquest court in Gqeberha. And the transcripts are in the bundle. They're at pages 741 and 73. It's going to take way too much time to go through them in detail, so I'll do my best to summarize them.
May I possibly, sorry to interrupt, but I have a complete set of documents which we can move very quickly through. It's not going to take me time to read through them and explain what happened there, rather than reading all the...
Yes, no, we're certainly not going to read through the transcripts. There isn't time for that. Of course, if you wish to refer to anything specific, you are free to do so. I first want to make this abundantly clear. These accusations do not come from us. These are claims made by the two investigating officers. And we simply put them in the bundle to offer you an opportunity to respond. Is that clear, Mr. McAdam?
Yes, I must thank you for giving these transcripts to a mutual friend of ours who drew my attention to them, because I would have been completely unaware of those allegations until you filed your application to cross-examine, and it would not have given me sufficient opportunity to prepare and find undisputable evidence which refutes those allegations. So I'm very grateful to you for doing that.
Yes, of course, you deserve a proper opportunity to respond. Let's deal with the allegations made by Captain Kla Masagela. And they go over many pages, but essentially what he's saying is that he claims to have seen the docket in your office in 2017 when, according to you, the docket wouldn't have been there because it would have been either with the NDPP or with Advocate Jiba. What is your response to that?
He's mistaken, Madam Chair. You'll see on NJ1, which Advocate Jiba filed, and that is that their handwritten notes made by myself, which I say the investigating officer has brought that docket in 29 April 2013. Yeah, 2013. In 2017, I was not dealing at all with TRC cases. I was dealing with very complex terrorism-related matters which kept me almost on a weekly basis in Johannesburg, either in the Magistrates Court or the High Court. So if he says that,
Right.
I don't say he's lying. I think he's mistaken, because that never happened. There is the injury. He brought it in 29th of April.
And before we turn to Makua, is there anything else you wish to respond in relation to Mr. Geller?
Madam Chair, my view is, insofar as his version might differ from mine, I would attribute to, firstly, he was unaware of what happened in the NPA after he dropped that docket off in April 2013. And secondly, it would appear from the transcript, he was only approached at this matter for the purpose of the inquest and did not make a contemporaneous statement. So that is my explanation as to the difference between my version and his version.
Okay. I should also point out that if you look at the transcript, my name appears as the cross-examiner, although in fact that wasn't the case. It was my junior, Mr. Suleiman, posing those questions. But let's turn to the allegations made by Mr. Makua. And I'm going to summarize it. I'm going to rely on the paragraph 18 on page 4 of our cross-examination application. Makua testified that he took over the investigation in 2018 after Masakela retired. He alleged that he approached McAdam after taking over but was not provided the docket. McAdam informed him after several months that the docket was missing. According to Makua, he was stopped by McAdam from making queries with Advocate Jiba about the missing docket. Makua was ultimately responsible for reconstructing the missing docket with claimed little assistance from McAdam. You've given the references. Your response?
My response is, I am very, very sad to actually say that in respect of a colonel in the senior position in a head office. It is a complete fabrication. I have all the documentation which disproves it. If I'm given permission, I will take the Commission through those documents and make them available to the parties.
We would like you to make them available, but we're not going to ask you to take the Commission through the documents unless the Commission requires it.
Well, I can quickly summarize, and if there's any dispute, the documents are available. But the fact of the matter is... Sorry,
Mr. McAdam, our time is quite limited. I just want to put one more allegation to you, and you can quickly deal with it. It's not going to take long, and that's the next paragraph. Makua testified that he did not believe that the docket went missing by accident, but that powerful forces were protecting high-ranking suspects in the matter. He claimed that from the behavior of McAdam, he was the person who was protecting the suspects. The transcript references are there. Your quick response?
And strongly deny that. If I'm afforded an opportunity to take you through the documents, you'll see a totally different story.
Yes, indeed. And Mr. McAdam, we are not contesting your version on these aspects. So please do hand over those documents. But we would like to move on in the interest of time.
So can we leave this matter and simply documents are available and will be perused? I don't need to answer any of these questions. My denial of...
Yes, indeed.
No, I'm very grateful. That
unless
will
the
save us a lot
Commission
of
directs
time.
otherwise.
Yes,
Yes, indeed, unless the Commission directs otherwise.
yes. I think that is the appropriate course to take.
Certainly, Madam Chair, then I have nothing further to say on the matter. All the documents will be available to the parties and to the inquiry itself.
Thank you, Chairperson, and thank you, Mr. McAdam, for making those documents available. Now, I want to draw your attention to certain documents. that former NDPP advocate Batoy directed to Minister Lamola. And this took place while you were the special director of the PCLU. Correct me if I'm wrong, but
Sorry, Mr.
as
Can you just wait a bit?
Thank you, Mr. Vani.
thank you, Chairperson. May I proceed?
Yes, you may proceed.
As the Chairperson pleases. Mr. McAdam, as I understand your career at the PCLU, you were placed in charge of that body in 2019, and you remained in charge of the TRC cases till September 2021. Would that be correct?
That is correct, yes.
And would it also be correct that in correspondence or communications that the NDPP would make to the minister or other parties in relation to the TRC cases, that she would quite likely depend on your inputs?
Correct. My inputs and Advocate de Kock, who is my supervisor. We compiled the document together, and Advocate de Kock submitted it to Advocate Batoy, saying for her to peruse, and if she agrees, to transmit it to the minister.
Right. Can you just remind me of the date in June, if you can, at least in 2019, if you can remember, when you became the special director?
April 2019.
Thank you. All right, so we did put up a short supplementary bundle, and I'm just going to refer you to two of those documents. The first document is a memorandum from Advocate Toy to Minister Lamola. There's a date stamp on the front. It says 7 June 2019. But Advocate Batoy signed this memo on the 4th of June 2019. It's titled Response to a Complaint by Foundation for Human Rights.
I see the document, yes.
Yes, so that's at 511. Just to put everybody into the picture, that complaint by the foundation related to the allegations of interference in the TRC cases, as well as the call for an inquiry. And then you'll see at the bottom of the page, at 2.2, it reads, "It is unfortunately a fact that the PCLU was prevented from fulfilling its mandate in dealing with the TRC cases because of the following series of events." And then there's several bullet points that run onto the next page, 512. And this is essentially a summary of all the events we are familiar with, references to the Amnesty Task Team, and so on. So would I assume correctly that you would have made inputs into this memorandum?
That is correct. This memorandum was drafted by Advocate Batoy after a meeting with myself and Advocate Mzanyati, who was acting as her Deputy National, and after the High Court had delivered the judgment in the Rodriguez matter.
Yes. Actually, in this particular memorandum, it's apparent that it was drafted before the judgment came to the attention of Advocate Batoy, because if you look at the very next memorandum.
Sorry, I'm looking at the one where she indicated that she would approach the Chief Justice to appoint a retired judge to do an internal investigation into the allegations against the MPA. But now, let me see, the other one is response to complaint by a Foundation of Human Rights.
That is the one you are directed to Advocate McAdam.
Certainly, Madam Chair, I'm looking through it to see if I recognize this document. Yes, I do. So it was, I agree with what was said, that it was that we were waiting the judgment before she would take appropriate action.
Yes. And just because you were looking at the other document, if I can draw your attention to paragraph 2.2, where she says the PCLU was prevented. It's unfortunately a fact that the PCLU was prevented from fulfilling its mandate because of a series of events, and those are in the bullet points.
They were also the issues that we dealt with in length yesterday and today.
Yes, and I'm not asking you to go through them again. We don't have time for that repetition. But you're confirming that she would have, amongst other sources, relied on you for that information.
Correct, yes.
All right, then let's then move to the next document, the one that you were looking at previously. That is starts on page 517.
Yes, correct.
Now, you will note that Advocate Batoy also signed this on the same day, the 4th of June, 2019. And it's in this document that reference is in fact made to the judgment. So would I be right in saying that the judgment, which was in fact issued on the 3rd of June, came to the attention of yourself and colleagues and Advocate Batoy, perhaps during the course of the 4th of June, which prompted the next memo?
That's correct. It was actually I was mistaken. I made an error in thinking that the Chief Justice had the power to appoint retired judges, because that was my proposal.
I see. Okay. Can I ask why at that stage consideration wasn't given to an independent commission of inquiry with the normal powers of a commission that could investigate across departments and would have the power of subpoena and compulsion?
Madam Chair, as I read the judgment, I haven't looked at it since it was delivered. So what I seem to recall is that the court directed that the national director inquire into the cause of these delays and look at obstruction. So I took this that she would have to undertake her own investigation. That is why we said, normally when there's criticism leveled against the prosecutor or against the NPA, the national director will then appoint somebody senior who's not connected to the entities that are responsible for blame. They will then do an investigation and go back to the national director. But I said, given the serious nature of these matters and to demonstrate that we, as the NPA, have got nothing to hide, it would be appropriate for a retired judge to go into all the affairs of the NPA, submit a report to the NDPP, because she would obviously not have the power to go and investigate other departments and interrogate their records. But then the full version of the facts within the NPA would be assessed by a retired judge whose integrity and objectivity would be beyond repute, and I believe that that was the way that it would be dealt with.
Beyond reproach.
I beg your pardon?
I say beyond reproach. Whose
Oh,
integrity?
sorry, I apologize. My Duracell batteries are starting to run
Yeah.
flat, so I apologize, Commissioner.
If it's any consolation, Advocate McAdam, my Duracell batteries are also running out. Thanks for that explanation. Let's then turn to another document that's at page 435 of the bundle. I'll just wait for you to get there.
There we go. Sorry. Just very briefly, the Chief Justice replied to that letter saying he lacked the necessary power. I immediately drafted a memo in Advocate Toy's name to the Minister of Justice in which he asked the Minister to appoint a retired judge. The copy of the document I had was signed by Advocate Batoy, but I do not know what transferred further, what response there was from the Ministry. But again, we were wanting to move quickly and have a very objective investigation into the role of the NPA.
Thanks for that further information. All right, this is another memorandum from Advocate Batoy to the then Minister of Justice, Lamola. It's titled Briefing on TRC Cases. At the very top, you'll see it says in written, it says our copy at the top to Justice together with date, which looks like the.
As I
have to say,
mentioned, it's
actually,
8th of December 2020.
Yes, I think that's right. I also wanted to take you to the signature page on 448. So Advocate Batoy has signed it, and that looks like the 2nd of December 2020. But you will note that there are no signatures from the Acting Director General, the Deputy Minister, or the Minister. Firstly, would you have had input as well into this memorandum?
Correct. This is the memorandum that was a joint product between myself and Advocate de Kock, because from April 2020, Advocate de Kock was my supervisor on all the PCLU matters, including the TRC.
Yes, I think by that time he was overall in charge of the TRC cases.
That's correct, yes.
Now, this memo was put to Minister Lamola. He could not recall receiving it. Do you know whether it was sent, or do you assume it was sent?
I assume if Advocate Batoy signed it, it would have been sent, because she had a very efficient office manager and executive secretary. Normally, the problem is that the matters aren't signed by the national director because of other urgencies, and then you have to remind and follow up to get it signed.
Let me take you to page 443. And I want to read the first line of paragraph 2.29 into the record. The irreparable damage caused by the blocking of investigations for a period of 7 years cannot be underestimated. In addition to prescription now being applied to a number of new cases, a number of accused and state witnesses have died. And then the last paragraph I'll refer you to is on page 446. It reads, it matters to be noted at paragraph 3, and I'm just going to quote 3.1. The consequences of the willful blocking of TRC investigations at a critical time and for a protected period must be accepted and responsibility taken. This is one of the great impediments to being able to do justice to the cases. And then the rest of it, the NDPP offers to put up the documentary evidence and to make a presentation so that there is no misunderstanding of the issue and its consequences. Are you aware of any response or action taken as a result of this memo?
Not at all. Nothing. I never heard, but Advocate Victoria and Advocate de Kock never called me in to say this is the response, how do we take it further? All we did is the date December 2020 is significant. There was a workshop which I set up with all the DPCI members, the prosecutors, the DPPs, where we did an honest assessment of all the problems we were facing, resulting in me then submitting a memo to our HR department to get approval to appoint retired prosecutors on 3-year contracts so they could work full-time on these matters, and it would not have to be dealt with by court prosecutors who deal with this in between all their work. So that is what I did, as supported by the NPA, to try and improve the situation.
Thank you, Mr. McAdam. Mr. McAdam, you have a wealth of information at hand, and I could probably spend the rest of the afternoon picking your brain and putting more facts on the table, but I'm constrained by time because it is already 3 p.m. So I want to thank you for your stamina and your willingness to assist this commission. Chairperson, no further questions.
Thank you, Mr. Vani.
I was about to throw these Duracell batteries away if we wanted to go on, Madam Chair.
Keep them, Mr. Advocate McAdam.
Certainly, Madam Chair.
Yes. Mr. Soni?
Chairperson, can we have a 5-minute break? I just want to put my papers.
Yes. We'll adjourn for 5 minutes. Mr. Soni?
Thank you so much. Good afternoon again, Mr.
Afternoon, Advocate Soni.
McAdam, can I just start off?
You have to speak up, Mr. Soni.
I'm sorry. Can I start off with your appointment to the DSO? I understand you were appointed to the DSO in early 2001.
That's correct, yes.
Right. And before that, you were a prosecutor in KZN.
That's correct, except for a 2-year span with the TRC Commission.
Yes, I was going to come to that. So you've had experience
That's
with
correct.
the TRC as well.
Yes, that's right.
And then after you were transferred, after you joined the DSO, you were transferred to the PCLU in 2003 after it was established. I think
That's correct. June.
you said June 2003.
2003.
yesterday, yes. And you remained, for the most part, with the PCLU, doing work with the PCLU until your retirement in October 2021.
That's correct.
And there were during that time, there were 2 periods when you were not with the PCLU. That's in February 2002 to September 2008, when you were involved in that nuclear syndicate case.
What happened is I remained in the PCLU, but I was no longer able to work on the TRC cases.
Yes.
But in 2014, 2015, Mr. Nkosana relieved me of all my PCLU duties to give full-time attention to the foreign bribery cases.
Okay. Now, you were thereafter, as was pointed out earlier this afternoon, you were appointed as the head of the PCLU in March 2019.
My official appointment made by the Minister was in April 2019, but in March, Advocate Batoy informed me that she intended appointing me as the head.
Now, can I ask you, Mr. McAdam, would you please, and I'm going to deal with certain paragraphs of your affidavit, I ask you to, you don't have to go to it, but you're more than welcome to. I just want to alert the Commission as to where the information is
Certainly.
contained. In paragraph 8 of your affidavit, you say when...
Page?
Chairperson, page 232.
Is this the September 2026
It is,
affidavit?
yes, Commissioner. You say when Mr. Nuka became the NDPP in 1998, he established the Human Rights Investigative Unit. That's
Yes,
the HRI.
That's correct.
And its task was specifically to review and assess TRC matters so as to establish which TRC matters were ready for prosecution or required investigation.
That's correct. This unit was replacing the De Oliveira unit, which had been focusing on the security force cases.
Yes. Okay, then in paragraph 10 you say the HRIU was dissolved for 2 reasons. The first reason was the TRC amnesty process had not been concluded at that stage, and second, it had no investigators and could not conduct investigation.
That's correct, yes.
Then in paragraph 11 you say the DSO was established to investigate organized crime. Now I'm trying to draw a distinction between the HRIU and the DSO, and of course the other units that were established to deal with TRC matters.
Certainly, the unit that Mr. Nguka set up was comprised solely of prosecutors. So they were dependent at that stage there was no DSO, so they're dependent exclusively on the police conducting investigations as they had identified. Now, the DSO was unique in that it now enabled the NPA to not only deal with prosecutions but also to conduct its own investigations, and you had investigators who were not police officers, but they were conferred with the same powers as the police had. So that's the distinction.
Yes, yes. So these were what were referred to as prosecution-driven investigations.
Yes.
Or prosecution-led investigations.
Yes.
That was the DSO investigation.
Yes, and also the unit Mr. Nguka said, because here you had prosecutors evaluating material and assessing evidence even before they had investigators. So there was another proactive step taken by Mr. Nguka to give prompt attention to these matters.
Now this is prior to the PCLU, of course.
That's correct.
Now in paragraph 12 you say that when I joined the DSO, there were only 2 members, Mr. Tongwane and yourself.
That's correct, yes.
And then in paragraph 13 you say, at the DSO your role included investigating TRC cases and prosecutions, and because you and Mr. Tongwane were the only 2 members, it experienced operational difficulties due to lack of investigators and administrative support.
That's correct, yes.
And can I ask you to look at, well, I'm going to go to paragraph 15 of your affidavit. You say that within the DSO, the SNPU was established. You say that in paragraph 15. That's the Special National Projects Unit.
Yes.
And you were appointed the head of that unit.
That's correct, yes.
And its mandate was to conduct investigations into matters deemed too complex for the regional officers of the DSO, and its mandate also included TRC cases and to organize projects related to ongoing criminal activities.
Yes.
And then you say at paragraph 16, just like the you don't say this, but I'm just saying that just like the HRIU, the SNP was affected by a lack of resources.
That's correct, yes.
And that would be both administrative and investigative.
That's correct. All those constraints were set out in either AD1 or AD2 to the affidavit, where it was documented in detail what all the problems were.
Now, can I ask you, when we talk about human resources, are we also talking about prosecutors?
Yes, we are.
And then in paragraphs 17 and 18, you say to assist in this process, 4 investigators and a chief investigator were appointed in May 2002, and in addition, you referred to a matter earlier, 2 former TRC researchers were also appointed to your unit.
Yes. What happened is the decision to appoint those investigators was taken in May 2002, but they could only assume their duties in November 2002 because they had to finalize the investigations that they had been conducted in their regional offices.
And then you say in paragraph 19, with the, before I go into paragraph 19, how long did those researchers remain with the DSO or the SNPU?
They remained with the DSO right up to when Mr. Nguka in May 2003 2003 moved the prosecution of TRC cases to the PCLU. At that stage, I know the one researcher had got permanent employment in Cape Town, so she dropped out. The second researcher, however, continued to assist us until we then had to appoint her as the head of the missing persons task team. That was to address the finding made by the TRC that some 800 people had been had disappeared, and their remains had never been found. Nobody knew whether they're alive or dead. If they're dead, where are the skeletal remains? So she then had to head that unit. I had to draft the budget and all the motivations to then have that unit established within the NPA as a subcomponent now. So her primary responsibility shifted to this portfolio.
Mr. McAdam, please, I'm going to ask you to stick to the point. I'll tell you why. I'm asking these questions to raise certain specific issues, and details are going to cloud those issues that I want to raise.
No,
if
no.
I want detail, and I don't mean to be disrespectful to you, Mr. McAdam.
No, certainly then.
And this person, incidentally, was Miss Fullard. Am I correct?
That's right, yes.
Now, with the assistance of these two researchers, you then compiled a report in which you set out 41 TRC matters, and that report appears as Annexure AD1 to your affidavit at pages 264 to 289. Would that be correct?
Yes.
Can I ask you, please, to turn to page 264?
I have it before me.
Now, there's certain parts of this report that I want to bring to your attention or place on record. The first is, it is addressed to the acting head of the DSO.
Yes, that's correct.
That's Advocate McCarthy.
That's right, yes.
And it is from you in your capacity as head of the SNPU.
Yes.
It's dated the 10th of February 2003. You'll see that on the
Yes.
third line. And then its title is Breakdown of TRC Investigations, yes.
Yes.
Now, can I then ask you to look at page, sorry, can I just say that in this matter you deal with the, as you say, the 41 TRC cases, and you deal with them consecutively.
That's right.
Numbered 1 to 41.
Yes.
Now ask you to look at page 264, please. Oh, sorry, it's 269. I'm just going to draw your attention, if you want to address any other matter. Some of the matters have been, some of the cases have been referred to earlier. You'll see at the top of page 269 is the case of case relating to the SAP General von Rensburg, and it deals with the Motherwell or Brian Ingalunga killing. This is a matter that I think my learned friend, Mr. Varney, raised with
Yes.
you on a number of occasions, yes. And then at page 274, you will see that at number 17, it deals with the case of Mrs. Victoria Nkenge, and that this case was being referred to on account of the huge public interest.
Yes.
Can I, while we're on that, I see that in respect of each of the cases, you set out in some detail the matters that you rely on and the possibilities in respect of the case. For example, in this case, you say locate the original inquest and police docket, locate TRC material, follow-up information. it's a very detailed document
Yes,
in relation to these 41
Yes.
cases. And I'm saying it as a matter of compliment, Mr.
Thank you.
Then, if you look at page 275, right at the bottom, is the case of Mr. Steve Biko, and it's quite coincidental that the inquest into
Yes,
his
that's correct.
death started just yesterday. Sorry, on Monday.
Yes,
It
I'm
just-
aware it's
oh,
this
yes,
week
yes.
was in
Yes.
court, yes.
Okay. And in his case, the issue was the possibility of investigating whether people should be held responsible on the basis that he'd been murdered.
Yes, that's right.
And then here you say that there was a refusal of amnesty and the subject died in police detention. Amnesty had been refused, but the Grahamstown DPP declined to prosecute.
That's correct, yes.
I take it one of the issues that would have arisen, and I say would have, you'll see, because the matter is eventually closed at that time, but would have arisen is whether the NDPP could revisit that decision.
That's correct.
As
That-
he is entitled to do.
Yeah, and as I was entitled to as well, I had the report of the DPP, and why I registered the matter is to look at it again and see if there isn't a possibility of proving a criminal case. So that's why I wanted to investigate and see if we can actually get to a criminal charge.
Right. Okay. And then on page 277 is the Craddock 4 matter, number 21.
Yes.
And at page 282 is a matter that also featured in your evidence yesterday, at number 29, the Anton Lubitsky
Yes.
allegations relating to whether his death had been planned in South Africa.
That's right.
Now, I ask you to look at page 289 of that report, or page 289 of the papers, which is the last page of that report. And these are your general comments. The first comment you make it is anticipated that the successful investigation of the above will lead to the detection of further unsolved crimes.
That's correct.
And how would that happen?
I believe I've dealt extensively with accomplice witnesses, and if you have a successful prosecution, people who've been sitting out of the process suddenly come forward because they don't want to be the next person to be prosecuted, they want to be the next state witness.
Then the second point you make is now that researchers have been appointed, the TRC material is being evaluated on a systematic basis, which will lead to further investigations being registered.
That's correct.
So you had two of the researchers from the TRC,
Yes.
and they assisted in compiling these 41 cases.
Yes.
And of course, based on amnesty applications and complaints made to the complaints unit at the TRC,
Yes.
that more cases would be added in respect of possible criminal
Yes.
prosecutions. Then you say, due to the small number of staff members, the investigations are prioritized according to their degree of urgency. However, it remains the policy of my office to deal with the matters holistically once the final report of the TRC has been received and analyzed.
Yes, that's correct.
And that was the approach you were going to take,
That's right.
to await the report, which would, in any case, in this case, was going to come in about 4 months.
Yeah, but although we were waiting for the report before we make decisions, the work that we had identified was continuing. So we didn't stop and say we'll only start once we get the report.
No, I understand perfectly. All right. Now, this report was submitted to the head of the DSO.
That's correct.
Can I ask you, Ms. McAdam, and you would know this, you're appointed to the DSO, which is just formed in 2021. You're the first head of the SNPU. Was this the first? Oh, sorry. Were you the? Was this the first, if I can call it, list of cases that you were aware of where possible investigations?
That's correct, yes.
And with the depth of analysis that is included.
Yes, that's correct, yes.
As I understand it, though, there may have been lists of possible cases, but not where the facts had been considered holistically as was done in this report.
That's correct, yes.
Now, can I then ask you, this report was sent to the DSO, the acting head of the DSO.
Yes, that's right.
What was his response?
He said we continue. You know, he was satisfied with what I'd reported, and the DSO continued working on these matters until Mr. Bulalani made that decision to move the prosecution component to the PCLU.
Yes.
2003, who was the head of the DSO?
That was Advocate Leonard McCarthy.
Okay.
Now, the reason I ask Mr. McAdam is you complain in the third point you make at page 289 that due to the small number of staff, the investigations are prioritized, and of course the list has to be included. Was there no indication that, look, carry on, we're going to give you more people to do this important work?
Madam Chair, the DSO had just set up as a totally new unit established from scratch, so there were major concerns with resources in all the components of the DSO.
All right. Can I then ask you to go back to the affidavit and look at paragraph 23, please. Page 236. You say there that in May 2003, Mr. Advocate Ackerman invited you to serve as his deputy on the newly established PCLU. Is that correct?
Yes.
Yes. And this had been established by presidential proclamation, which appears as AD3, page 292. Can I ask you quickly to look at that, please?
Certainly.
Now, this is the unit set up by the president by virtue of the powers he has under section 13(1)(c) of the National
You have to
Constitution.
refer to the page, Mr. Sir.
Sorry,
292.
292, yes.
Oh, sorry, I missed it, sorry.
And I just want to refer you to what the mandate of the PCLU in terms of the proclamation was to manage and direct investigation and prosecutions of crimes contemplated, one, in the implementation of the Rome Statute of the Rome Statute. That correct?
Yes, that's right.
And crimes of the International Criminal Court.
That's correct.
And serious national and international crimes, which includes acts of terrorism, sabotage, committed under the Internal Security Act of 1982, high treason, sedition, foreign military crimes committed by mercenaries, or such other priority crimes to be determined by the National Director.
Correct, yes.
Okay. Now, in your evidence yesterday, you pointed out that one of the matters that the PCLU, or among the matters that the PCLU was dealing with, or started dealing with, was that of foreign mercenaries and so on.
Yes.
And of course there were the Pagad matters as well.
We didn't deal with the Pagad matters at all.
Or was that when you...
That was dealt with by the Western Cape office under the DSO, and they continued with those investigations.
Now, I take it before the crimes to be investigated by the PCLU were identified, set out in the proclamation, it would have been clear to the prosecuting authorities or the wider set of authorities dealing with criminal matters that these are crimes that require intensive investigation and people with enough experience.
That's correct, yes.
And that there would be a fair amount of these investigations and prosecutions that would be taken.
Yes.
Now, can I then ask you to please turn to your paragraph 25 of your affidavit. It says, on the 15th of May, I addressed an internal memorandum to the NDPP, the head of the DSO, the DSO operations, and Mr. Ackerman, which provided details of an audit of TRC cases. And that is contained as Annexure AD4.
Correct, yes.
Can I just ask, before we go to it, the audit that you did in February was to some extent replicated without the details. In other words, a number of
yes.
cases, and a couple of cases were added to it.
Because we've done more work between February and May, which were then captured in this report.
And I'm going to come to that because you then divide the cases into different categories.
Yes, that's right.
Categories. So can we then go to AD4, which appears at page 293 to 297. And if I could just ask to look at page 293, this document is addressed to the NDPP, and it's CC'd to the head of the DSO, the head of operations, and Advocate Ackerman, obviously in his capacity as the head of the PCLU.
Yes, that's right. Okay.
And it's from yourself in your capacity as head of the SNPU, dated the 15th of May, and this document is titled Audit of TRC Cases.
Yes.
Now, can I just ask you the headings to the cases? You'll see on page 293, the first heading is cases being prepared for prosecution.
Right.
And you list the cases. I'm going to come back to that. And the second heading on page 295 is potential further prosecutions arising from the above. And you list 2 cases there. And then the next heading is new cases being evaluated for prosecution purposes. And then D is high interest cases which require attention irrespective of the nature of the available evidence. And the next heading is, or category of cases, is representations to investigate specific cases. And then the last category is cases in the process of being closed.
Yes.
So that's the work, at any rate, at least what had been done between February and this document is that you had now categorized how these matters will be dealt with.
Yes.
And I just, on that score, dealing with the different headings, you'll see that the first heading is the Motherwell bombing case, which we'd already referred to in the previous document, and then the Brian Ingalunga case. Is that
Yes.
correct? And then there's the Pepco case, and of course the Philip Powell case, which is at number 5. And these are the cases, as I understand it, that appeared to be somewhat ready for prosecutions.
Yes.
Okay. Then the next category of cases is potential further prosecutions, and you'll see there at the number 1 is the murder of the Pepco 3, and you'll see on page 294 the Pepco 3 is mentioned there as well. I take it you were going to do this matter in stages.
Yes, that's right.
Okay. And then the second case in that category of further prosecutions was the Craddock 4 case.
That's right, yes.
Then the new cases that were being evaluated, one of them is the Kossas, the murder of the Kossas 4, and that's the first one
Yes.
under C.
That's right.
And then, as was done in the previous matter, you talk about, well, sorry, not as was done, but one of the cases you mentioned in the earlier memo was cases of high public interest, and the first case mentioned here is the murder of Mrs. Nkenge.
Yes.
Then you refer to the representations to investigate specific matters, and the first one on that list is the death in detention of Mr. Ahmed Timor.
Correct.
I want to come back to that in a minute. Perhaps I should just deal with it while we're at it. If you look at page 290, Mr. Ackerman, of your of the annexures, and that's annexure AD2, you indicate here the reason why it appears to be on this list. And
Yes.
you set out how it came about, namely that you were approached by Mr. Timol's nephew, Mr. Kaji, on the 2nd of May, and then you asked Mr. Leask to do certain investigations.
That's right. Yes.
Okay. And again, that would feed into the notion that this list was going to be amplified as circumstances require.
That's correct.
And as you say here, it was on the basis of representations made by interested parties, in this case a family member.
Yes, that's right.
And then in F you say you deal with the cases that were in the process of being closed, and in number 5 you record that the case of the murder of Steve Biko, which had been classified as murder in the previous memo, but it was now going to be closed because the prior crime had prescribed in 1997.
That's correct, yes.
And that's, I take it, you had downgraded the investigation from murder into culpable homicide.
No,
Or
what had
am I
happened
wrong?
is I had consulted with the chief state pathologist. We'd gone through all the medical evidence, and the issue in that case of that a head injury had been sustained in a altercation, and the view is that that head injury was fatal in its own right. The person would have died no matter what happened, and that was a bar to now holding the people who afterwards denied him medical treatment, transported him to Pretoria in the back of a Land Rover, and possible and actions in the Pretoria prison. You see, if prescription didn't apply, I would have still gone ahead on culpable homicide charges, but I couldn't prove murder. And a lot of the key role players who were involved in the subsequent treatment had already died.
Then on the next page, investigations put on hold is the first one on that list is the murder of Advocate Lebowski in Namibia.
That's right, yes.
Then can I ask you to look at J, where you set out policy considerations that informed this memorandum.
Sorry, I'm just going back to, I take it this is my AD4.
AD4, yes.
And if I go to the last page.
Yes. Yeah, so that's where...
There you are, there you have it.
Okay. Now, the first consideration you set out is prosecutions not to be conducted on a piecemeal basis except where special circumstances are present, namely, for example, as a witness on the point of death, and so on. Is that right?
Yes, that's correct.
And the second is, once all the cases earmarked for prosecution have been investigated, a presentation will be given to the NDPP in order for him to confirm the prosecution strategy. Thereafter, prosecutions will be instituted. And then the third point you make is, after convictions have been obtained, attention will be given to cases which currently had evidence, since convictions may act as an incentive for perpetrators to come forward. That's the point you made.
Yes.
When we talked earlier.
That's correct, yes.
I just want to go back to paragraph 2 of your policy considerations. As I understand it, and I may be wrong, what you were intending to do was to do all the investigations first and then start the prosecutions.
Yes. I very quickly had to revisit that. Firstly, lack of resources. It would take too long. So by the time witnesses and accused would have died, and also to make an impact on the strongest cases. So on reflection, we did not follow that approach.
Okay. And it made sense given the fact that you'd been complaining throughout, and
Yes.
that's specifically why I read those paragraphs of your affidavit. You'd been complaining about lack of resources.
Yes.
Because on this basis, there would have been no investigations until about 4 or 5 years ago.
Yes, that's correct.
Well, no prosecutions, not investigations.
That's right.
But this is the other part that I want to ask you about, Mr. McAdam. You say that a presentation will be given to the NDPP for him to confirm the prosecution strategy. Now, what was the prosecution strategy?
That is what we had set out in here, where we'd said cases for prosecution, high interest cases, representation cases. This is what we presented to him at our meeting with him.
In other words, dividing the cases
Into these categories and prioritizing according to into which category a case fell.
All right. Now, what was his response to the prosecution strategy?
He endorsed it, and that's why we started working according to that strategy.
Okay. Now, aside from that particular strategy of dividing the cases into different categories. Was there any other prosecution strategy that had been developed from the time the PCLU was established?
No.
Can I then ask you, Mr. McAdam, to turn to paragraph 26 on page 290, 230, 237, sorry, Chairperson, sorry. You then deal with the fact that now that you were in a position to prosecute, you needed DSO investigators.
That's correct.
And that's where the disputes and so on with Mr. Ledwaba
Surface,
came up.
yes.
I want to deal with that at a later stage, if you don't mind.
Certainly.
Can I then ask you to please look at paragraph 28? Where you say that on the 23rd of May 2003, Mr. Ackerman addressed an internal memo to the NDPP requesting a meeting to discuss specifically the progress made by the PCLU, and his memorandum is at AD 6. We don't need to go to that, but we know there is a request for a meeting.
Yes.
Okay. Then can I ask you to please look at page 2, paragraph 29. This is now Mr. Ackerman's memorandum to the NDPP, which appears as AD 7 to your affidavit at page 301. Now, this is a document authored by Advocate Ackerman. It's addressed to the NDPP, and Dr. Ramaite and Advocate McCarthy are CC'd on it. It's dated the 26th of May, and it deals with TRC cases.
Yes.
The first few paragraphs...
26th of May 2003.
2003, sorry, Commissioner. Now, the first three or four paragraphs, subparagraphs, gives a history of the matter as set out as has been summarized in your affidavit.
Yes.
To a large extent.
That's correct.
Yes.
Yes.
Can I ask you, though, to look at on page 302,
I have the page in front of me.
C, paragraph C, towards the bottom end of page 302, where it is said that the following steps were undertaken, and in C it is said a business plan was completed and delegations as required by the NPA were made. Where is that business plan?
The business plan, I'll look for it. I did have it at a certain stage. If I find it, I'll definitely make it available to the inquiry.
Now, you seem to recall what it you seem to recall the document. Can you recall just the issues that were addressed? in the
What
business
you see with the DSO, they work on a project basis, and unlike the police, they can select what cases they will or won't investigate. So this was to comply with the DSO requirements, namely we'd say more or less what we've set out in our report, but without referring to specific cases. We're just saying processes, investigations, where we need researchers, etc. And then also it included a budget, and the budget would be allocated to the whole project. So when you start doing individual cases, you don't have to have a separate budget for each case. You work out of the existing budget. If I find those two documents, I will most certainly make them available.
Okay. Now, would that indicate cost matters or financial, resource matters?
Yes, it would. And we had to specifically say how much this process is going to be cost, and breaking it down into vehicles, cell phones, travel.
And to the best of your knowledge, was the business plan approved?
No, it wasn't. This was the dispute with Advocate Ledwaba. We'd submitted the business plan, the budget, and then the application for these authorizations, and nothing was approved.
Now, was it because of the authorizations or the financial implications?
I don't know. He just said he decided summarily that all these cases must go to the police. He didn't give us any reasons for that decision.
And the business plan was sent to whom? To the head of the DSO?
I'll have to check. It would have definitely gone to Advocate Ledwaba, because when he authorizes the investigation, he has to be satisfied that we have sufficient budget to cover the investigations, and also for audit purposes. When the Auditor General comes in, they'll say, but are what we're doing actually covered in this business plan?
And then can I ask you to look at page 303 of that document, Mr.
Yes.
Mr. McAdam, and you'll see at the bottom is paragraph B, the cases dealt with by Advocate Fick, and you say a number of dockets were collected, but investigation suspended due to an instruction from your office in January 1991. Now, this, I take
1999.
I'm sorry, it is 1999. This is addressed to the NDPP.
That's correct. And your office is it was an instruction by Mr. Nuka personally.
Yes. And what was the reason for that?
Madam Chair, in 1999, the TRC was still only at an infancy stage with amnesty applications. So you don't want to investigate cases where the perpetrators will get amnesty and there'll be no prosecutions. And in respect to the ANC cases, all the cases having prosecution potential were prosecuted, and subsequently the perpetrators got amnesty.
Oh, so it was just purely on the basis that we must await
the amnesty judgments, yes.
Then can I ask you to please look at paragraph 30 of your affidavit? Oh, sorry, can I ask you please to turn to page 304?
Yes, I have it in front of me.
Yes. So these were the proposals that Mr. Ackerman had made. Were those proposals accepted?
No, well, let me see. Paragraph 1, that Advocate Ackerman would take over the role that was done. 2 was done, McAdam and Pretorius were transferred. The request to give Advocate Ackerman DSO powers was not approved. And then I think we're missing a page, because there were requests for secondment of investigators and the transfer of Advocate Tongwani, which also was not approved.
So on the basis of what was approved, the position would be that it would be Advocate Ackerman, yourself, and Advocate Pretorius who would be the members of this unit.
That's right, yes.
Can I ask you then to please look at paragraph 30 of your affidavit? So you recall earlier you had mentioned that Advocate Ackerman had asked for a meeting with the NDPP.
Yes.
And I take it this is the meeting that eventuated out of that request.
Yes, that's right.
Okay. So you say a meeting was held, and present at that meeting were Ms. Nuka, Advocate Ackerman, and yourself, and you think probably, possibly Mr. McCarthy and Dr. Ramaite. Is that correct?
Yes, it is, yes.
And then that's where the proposals that that's the response to the various proposals.
That's correct, yes.
And then in paragraph 3.3 you say the NDPP directed that I continue working on the TRC cases I had handled at the DSO. The request to second 6 DSO investigators to the PCLU was not approved, but Mr. Nuka made it clear that the investigation should be conducted by DSO members.
That's right.
Now, can I ask, the difference between having these persons seconded to your unit would be that effectively you would be able to bypass the Section 28 process.
No, we would still have to comply with Section 28, but the investigators would be working directly with us, not doing any other DSO matters, and being directly tasked. Whereas if they're not seconded, then all our requests will have to go through Advocate Ledwaba once he's approved the authorization of investigations.
And the availability would determine when they would
Yes,
be
that's right.
available
So
to
if you
you.
had them seconded, you could move quicker.
And then you point out that at that meeting, Mr. Nuka didn't transfer TRC cases to the PCLU, but he did so later in a proclamation that he issued.
That's right. Yes.
And that appears at AD8 at page 308.
Yes, that's right.
And in doing so, he was exercising the powers granted to him by the President's proclamation.
That's
of
right, to
March.
refer other priority crimes.
Yes. Now, can I ask you to please look at page 239 of your affidavit, paragraph 31.1, please.
Yes, I have it.
You'll see it starts at paragraph at page 238. The part I want to alert you to is this. It says, because Mr. Nuka indicated that TRC investigations should be conducted by the DSO, I was still required to have the national project proposal approved and submit applications under Section 28 in respect of all matters that are required to be investigated.
Yes, that's right.
Now, the position, Mr. McAdam, that I want to suggest to you based on what happens, because thereafter in your affidavit you deal with matters that happened somewhat later. The position I want to submit to you, as at the time of the meeting and at the time of the memos, is it was quite clear that the work of the PCLU would not be efficiently implemented unless there were more resources available.
That's correct, yes.
And that was made clear by all the complaints that, all the observations you made about the lack of resources.
Yes, that is
and
correct.
why things had not been moving forward.
Yes.
Now, the evidence that we have is that these matters were not attended to. In other words, the resources that you had asked for, the extra investigators you had asked for, had not been attended.
No, but we still continued working.
Oh, yes. No, I accept that. I'm not.
Yes.
I'm not criticizing you because the decision didn't rest with you.
Yes, yeah.
Now, at that time, though, or soon thereafter, it would have been clear to you, Mr. Ackerman, Mr. Advocate Ackerman, Advocate Pretorius, that look, this is not working as efficiently as it should. We are not moving fast enough on these matters.
Yes.
Where any requests, demands, whatever one wants to call it, made in respect of the provision?
Yes, that is correct. There is a memo which I can make available where Dr. Ramahiti, in the beginning of 2005, wrote to Advocate Macaulay, indicating all the resource constraints, setting them out in very detail, and then asking for Advocate Macaulay to make interventions. There was also a report that I wrote to the chairperson of the MPA Budget Committee, where I also raised a number of budgetary concerns. Those two documents are available if required.
Okay. Let's start off though with Mr. Nuka. You've made both you and and Advocate Ackerman had made requests to him, both at the meeting and in the memos you submitted to him.
Yes.
He didn't respond positively.
That's correct, yes.
And then you say Dr. Ramaite in 2005 made a request to Advocate Piccoli.
That's correct.
And that too, what happened to that request?
We were given additional resources. Advocate Piccoli approved the appointment of 2 senior state advocate posts. He approved giving us a proper office, and we were also permitted to also fill a admin post.
We know, though, that whilst you needed more advocates, the real problem was investigators.
That's correct, because everything required investigation. So at that stage, they were more important than prosecutors.
Now, when Advocate Piccoli became the NDPP, your dispute with Mr. Ledwaba would have taken on a different turn, I take it, because Mr. Piccoli would have understood the necessity for more investigators.
Yes, that's right.
And did it improve?
The problem was in 2005 was there was this moratorium on investigations and prosecutions imposed in, I think, either November or December 2004. And Advocate Piccoli maintained the moratorium until the prosecution guidelines were adopted, which was done in December 2005.
So until then, there was, from November 2004, when Mr. Ramaite says the minister told him to hold on with the TRC cases until from November 2004 to 2005, this moratorium remained in place.
That is correct.
And it was a moratorium that Advocate Piccoli accepted.
That's right.
Now, the point I want to make, Ms. McAdam, is, and you were appointed as the head of the PCLU in 2019.
Yes.
And you've outlined in your affidavit the steps that were taken. And I'll just summarize them very briefly. Among the steps that were taken is that more people were employed as prosecutors, even if purely on contract.
That's right, yes.
And negotiations were held with the DPCI where they appointed experienced investigators, if only on three-year contracts
That's
or
correct,
whatever
yes.
it is. The third improvement made was that the persons involved in TRC cases would devote all their attention to TRC matters and not be
Diverted.
diverted, that's perhaps the best word, with other matters, which would mean that the continuity you talk about would not be there.
That's right, yes.
And it is those matters that effectively led to the improvement you talk about, the number of cases increasing from 52 to about 114 by the time you...
That's right.
Now, I'm making this point, and I'm not saying that's the sole reason, but the one thing we can say is this: had proper resources been made available, then the unacceptable delays, whether from 2003 or from 2005 or from 2010, simply would not have taken.
That's correct, yes.
We can accept that one of the reasons for the delays was the fact that resources were being withheld, well, no, I mean, resources were not being provided as should have been provided.
That's correct, yes.
Now, Minister Lamola came and gave evidence here and made the point that when he became aware that these were the problems, he put the machinery in place for these resources to be made available, and that's when they were made available.
I think you see, what I had done was on my own initiative. It wasn't dependent on Minister Lamola. It was the MPA getting approval and the police getting approval. But I think when it's taken further after I'd retired, when there's now this full-time unit and large numbers of prosecutors, investigators, that would be the initiatives that are being taken by Minister Lamola.
So can I just ask then, because that might just give a different perspective, I perhaps have put things in a different context.
Yes.
You say that even before Minister Lamola came on the scene, the situation began to improve.
That's correct.
Yes, no, carry on.
No, in January 2000, General Labia undertook to take the necessary steps to get those 40 contract policemen. In December 20, when we realized there was a problem with prosecutors trying to do cases in between, we started immediately taking steps to now also match the police, get full-time prosecutors on contract. In July 21, the first contract police officers started working. Because there were delays in getting approval from the Department of Public Service Administration, we only got approval to appoint contract prosecutors in September 2021, but the DPPs had already identified how many prosecutors they need for their divisions, so that had all been done.
But the one thing we know is that in 2003 and 2004, 2002, 2003, you had already tried to get that, but
Without
unsuccessfully.
success, yes.
And do you know what perhaps changed the climate?
Madam Chair, at that stage, 2019, there was a buy-in by the police, the MPA, that these matters had to be properly dealt with. The necessary steps were taken to make those improvements.
Can I ask you, and you were there at the time, and it's not I'm not asking you to speculate, but one of the issues that has emerged in the evidence is there was a serious dispute between Commissioner Salebi and, on the one hand, and Advocate Nguka on the other, and then Salebi and Advocate Piccoli on the other.
That's right, yes.
And to some extent, when this matter was raised with you yesterday, you made the point that this was an organizational issue which should have been resolved at that level. You didn't need a political intervention.
Yes, that's right.
Is that what prevailed throughout that throughout the period, from that time when these high-ranking officials couldn't get on, or were there some other factors?
Well, first there was a conflict between Commissioner Salebi and Mr. Nguka. Then there was stopping Advocate Ackerman instituting the first Chikani prosecution, the moratorium on investigations and prosecutions, the task team that took a year to set up and failed to actually get any investigations going. Then my lobbying from mid-2008 right up until the end of 2009 to get a buy-in from the police that they will now do all the investigations. And then that was when, 2010, the police did start investigating the matters.
But as I understand it, although the police started investigating in 2010, the real progress only took place from around 2019.
Yes, that's correct. Because as we said, there were lots of capacity and skills constraints with the police investigations that started in 2010, resulting in General Labia agreeing now to have full-time, experienced, retired police officers to do the investigations.
But that was not done between 2010 and 2009.
That's correct, yes.
And so that would be part of the problem, because it would be the similar problem that you faced in 2002 and 2003.
Yes, that's right.
Now, I want to move to a different topic, and I don't want to spend too much of time on this. It's the Section 28 dispute between you and Advocate Ackerman on the one hand and Advocate Ledwaba on the other.
Yes.
Now, Advocate Ledwaba gave evidence, and I'm just putting the version to you so it doesn't go unanswered, because his evidence was led here and it was not put to you. This is what he says. He says that the reason he didn't approve the approvals in terms of Section 28(1)(a) is the applications that came before him did not pass the threshold. This, I'm giving you his evidence, and you can accept it for what it is worth. But it didn't pass the threshold. And when Mr. Nguka, as the NDPP, issued the Section 28(1)(b) directives, he could do so because that threshold did not apply to him.
That threshold had to be complied with by Mr. Nguka. Before he could refer the matter to the DSO, he then had to have satisfied himself there was a basis either for a full investigation or a preparatory investigation. So it did not permit the National Director to refer flimsy cases. All it means is he makes the decision and not Advocate Ledwaba. As far as his first point about these not reaching the threshold, I would have expected him to write directly to me saying why he's not proving, to give me an opportunity to submit proper, more detailed applications so that we can address his concerns. He didn't do that. I have my applications with me. I will make them available to the Commission to see how thoroughly those applications were drafted.
Okay, but it's also quite clear because you say that the meeting that you and Mr. Ackerman, Advocate Ackerman had with him was an unpleasant meeting.
That's correct, yes.
It's quite clear from your evidence and Mr. Ledwaba's evidence that there was some tension between you.
Are your batteries running low, Mr.
You need me to speak up. I'm sorry, Commissioner.
We're hoping they run so low that it'll stop soon.
Yes, continue,
I
please.
think my learned friend must direct his attention to the person who conducted a cross-examination before I did. I've not been on my feet for more than 45 minutes. But Mr. Advocate McAdam, I'm putting that on the table so that you have an opportunity to respond.
The only tension arose from the manner in which he conducted himself at that meeting. Advocate Ackerman and he were both directors, deputy directors in the DPP's office. And when Advocate Ackerman was appointed as a special director and he is an investigator, those are similar ranks. Because I think I saw Advocate Ledwaba's affidavit to which he claimed now Advocate Ackerman was a lower rank than he was. Now, my position is I was, since 1992, a deputy director of public prosecutions. I didn't have any dealings at all with Mr. Ledwaba until 2002, when he was the investigating director, and I was then in a DSO subcomponent which reported directly to the head of DSO, firstly Advocate Son and thereafter Advocate. And I am unaware of any tension between us, specifically when he claims now I resent the fact that he is of a higher rank than me. I didn't have any resentment at all.
Okay. Anyway, I've cleared that because I have
yes,
a duty
for-
as one of the
Yes.
evidence leaders to put his version to you. Can I ask you, in relation to the point he made, I take it you are familiar with what is happening at the Madlanga Commission, and that is an issue that has been raised in that commission about the threshold for a Section 28(1)A.
That's correct, yes.
investigation. So I'm again saying that as a matter of law, his caution may not have been totally unreasonable. I'm not saying it was justified. I'm only placing that on record.
Well, Madam Chair, as I said, if that was the reason, he should have told us. He has two options, because in terms of the Powell and the Hyundai decisions in 2000 and 2004, a investigating director, if he believes there are not reasonable grounds for the investigation, but there is evidence of a specified offence, then he can declare a preparatory investigation to then find that lacking reasonable evidence. So He could have declared preparatory investigations on these matters, or he could have sent the matters back to me and said, these are the loopholes. You're not addressing this point. You haven't given me enough there. And we would have addressed those issues and resubmitted. None of that happened.
Can I ask you now to turn your attention to the complaint made by Mr. Kaji? This is in regard to the Amatimol matter.
Yes.
I've mentioned it already. We know it didn't appear in AD1, that's your first February report. It appeared in your May report, AD4, on the basis that representations have been made to you, and you've indicated what those representations.
Yes.
The issue that I want to raise with you is this. We know as a matter of fact that the Kaji file, the Timol file was closed, and I don't want to go through all the documents and offend my learned friend, your counsel, so I'm going to move faster. But can I ask you to please look at two documents created by the PCLU. The first one appears at page 190.
Yes.
This, Mr. McAdam, is a memorandum. It has been referred to you in a different context, but this is a memorandum that is prepared or is dated the 24th of October. It's prepared by Advocate Ackerman and addressed to Dr. Ramaite, and it deals with the audit of cases emanating from TRC process.
24th October 2006.
So did I not say that?
Carry on.
So if I can ask you to look at page 192.
Yes.
This deals with the detention of Amatimol, and this is what this report says. Now I want to place on record, Mr. McAdam, that I'm aware that between 2004 and 2008 you were not actively involved.
That's
in
correct.
TRC matters. So this is what it is one of the matters that is closed, and it is said almost as reasons for it. This matter relates to the death of Mr. Timol, who died in police detention on the 27th of October 1971 during interrogation. 2, there was an allegation that one of the interrogators has confessed to a journalist that Timol had been murdered, and this was followed up but was later denied by the said journalist. The matter was therefore closed. Now, the issue I want to ask you is, did you take this decision?
I did not. You'll see in this memo the names of the prosecutors making various decisions are listed. My name is not there. 2006, I was full-time occupied with the nuclear case. My assumption is that one of the persons who took over from me saw the letter which I wrote to Mr. Kaji on a PCLU letterhead in February 2000, but failed to see the letter that I'd written to Mr. Leesk in May 2003 as a member of the DSO, because I had to move officers from the DSO to PCLU, and we had severe resource.
The only question,
Yes.
really is, did you take the
No,
decision?
I
I
didn't.
tell you why I ask, and I want to get to the point. Advocate Ackerman was questioned about this, and he said it wasn't he who took the decision. He says he takes responsibility because he signed the document, but he didn't take the decision. Advocate Pretorius came here a week or two ago and was asked about this, and he said he didn't Of course, you were not there, and I accept that you didn't take the decision. Who else could have taken this decision?
Advocate Marga, who was assisting Advocate Ackerman with TRC cases after I was assigned other duties.
See, the difficulty I have with that explanation is if you look at page 194 and 3.17, 3.18, and 3.19 and 3.21, his name appears at all of those.
Okay, yes.
So if his name appears there, the question would be, if he took the decision, why does his name not appear here?
Madam Chair, I can't account for that. I didn't draft the letter, and I wasn't dealing with TRC cases at the time.
Right. I want to also refer you to the next matter on that list, namely the date and detention of Mr. Biko, and you'll see that at page 193 says the matter prescribed in 1997 as evidence only proves culpable homicide, which according to criminal law prescribes after 20 years. You didn't form this opinion for this reason, that the matter should be closed.
Madam Chair, what had happened is already in 2003 I'd consulted with the current chief state pathologist, and I'd already...
We've been through that. I'm just asking, did you take this decision?
Oh, yes, I did. Yes.
You did?
Yes.
Okay. The only question then is, as I understand it, you say that the only crime was culpable homicide. And that's the point that's made here.
That's correct, yes.
But earlier, as I understood it, you say there was no crime.
No, it was the DPP Eastern Cape who'd originally read the investigation, decided that he could not prosecute at all, but when I was seized with the matter, I went further into the matter, leading me to conclude that I could prove culpable homicide, but the matter had already prescribed. So although evidence was available, prescription had kicked in.
Coming back to Mr. Timol's matter, and we don't need to go into details because the facts are there. You did an opinion for Advocate Pretorius in regard to what to do in regard to the Timol, to the complaint of Mr. Kaji, that the matter was not being investigated.
Yes.
And your opinion was that an application to reopen the inquest should not be made.
My opinion was we must first exclude the possibility we can prove murder, and that we would then definitely reopen the inquest if we were not of the view we could institute a successful prosecution.
Okay, I just want to ask you to look at Annexure AD4 at page 342. And if I can refer you to page 347, where you say it is recommended that you, addressing Dr. Pretorius, advise the NDPP not to accede to the request to reopen the inquest until the investigations have been concluded and a decision taken not to prosecute, and 2, request the NDPP as a matter of urgency to make a decision as to whether the TRC matters must remain within the PCLU.
Yes, that's
that
correct.
is your recommendation?
Yes.
Yes. Now, I just want to deal with this quite quickly, Mr. McAdam. Dr. Pretorius didn't follow your advice. He applied for the inquest to be reopened.
Yes, that's correct. He he took the matter over with me and did all the further investigations and concluded that he could not institute a prosecution on murder, and then he followed the inquest route.
He applied to reopen the inquest.
That's correct, yes.
And that led to the decision, because the inquest court had found that Mr. Timol had probably been thrown from the 10th floor of John Foster Square, that the last person with whom he was, Mr. Rodriguez, that led to a prosecution being instituted against him.
Yes, that's correct.
And of course, he had passed away before the prosecution could in fact be instituted.
Yes, that's right.
Now, we also know that in regard to Mr. Biko, that matter has been reopened again, and a court will make a decision.
Yes, that's right.
Now, I raise these matters with you, Mr. McAdam, in this context. We are lawyers, and we know that we sometimes can make the wrong decision, whatever it is.
Yes.
Like all human beings. The point I want to make is that had there been sufficient human resources at the time these decisions were taken, the probability is that because more warm bodies were available, these so-called cold cases would not have been closed.
That's correct.
Finally, Mr. McCallum, I want to raise a matter with you. You were appointed to the DCO in 2001.
Yes.
Now, the DCO was dissolved in 2009.
That's right.
The DCO was
The
based...
DSO.
DSO.
DSO. Your batteries are running low, Mr. Soni.
I'm sorry, Chairperson.
Yes.
You must buy Duracell.
The DSO was dissolved in 2000 by virtue of a 2008 amendment, and the dissolution took place in 2009.
Yes, that's right.
The DSO is based on the following, that these would be prosecution, the investigations it conducted for the prosecutions it would institute would be prosecution-led.
That's right.
When the DSO was dissolved, the DPCI came into being.
That's right.
And the purpose of that was to ensure that criminal investigations would be taken over by the police.
That's right.
Now, can I ask you, in regard to investigation of TRC matters, as I understand it, because they started while the DSO, because the investigation started while the DSO was in existence, the investigations were prosecution-led.
That's right.
Is that still the position?
Yes, that's correct. I mean, the MPA in all serious cases applies the prosecutor guided investigation principles. So even if it's a police matter, prosecutor will work full time giving guidance to those investigations.
Now I'm asking you a different question.
Also, batteries are getting flat this time. Can you repeat it?
So I'm saying to you that when the DSO was dissolved and the DPCI was brought into being by virtue of Chapter 6A of the the Police Act as it now reads, that that type of prosecution-led investigations would be inconsistent with the new with the provisions of the Police Act as they now are?
No, the SAPS Act specifically made provision for the head of DPCI to request the National Director to have dedicated prosecutors available to guide the DPCI in their investigations.
Well, first let me ask you this. Was this matter investigated by the PCLU?
Which matter is that?
That whether the mechanism it had been using in terms of investigations would still be valid?
Correct, Madam Chair. You'll see that the police filed a number of letters which I wrote to Superintendent Bester, directing him on what needs to be done on the investigations, and thereafter the PCLU and the investigators engaged on an ongoing basis dealing with these matters.
So I just want to, and I'm just raising this because I don't know what the right answer is. Section 17F of the Police Act reads as follows. Multidisciplinary approach, and subsection 1 says, government departments or institutions shall, when required to do so, take reasonable steps to assist the directorate in the achievement of its objects, one of which is the investigation
Yes.
of priority crimes. Is that the provision you rely on?
Correct. No, I'm sure. I mean, look, I haven't looked at that act, but I'm sure there was another provision which specifically gave the head DPCI the power to request the National Director to make dedicated prosecutors available. And that is what happened. You had the PCLU, dedicated prosecutors, to do cases that fell within the mandate of the Crimes Against the State unit of the DPCI.
I just raised it because I thought if it had been investigated, we would be favored with an opinion which says that that would be consistent after the formation of the DPCI.
I can't comment on that. I wasn't involved at all about the legislation and transfer of powers at all, so I can't answer that question.
Chairperson, those are the questions. Those are the questions from us.
Advocate McAdam, can you hear me?
Yes, I can.
Thank you. Thank you for your evidence. It's been biblical. Could I just get some factual clarifications from you?
Certainly, Commissioner.
I'm unclear in my own head during your time at the PCLU when you were assigned to other cases. In the one affidavit I see 2004 to 2007, can you help?
Yes,
clear
I
up my
can.
thinking?
What happened is either at the end of February 2004, but definitely the 1st of March, I had to be taken, or not removed out of the PCLU, but taken off the TRC cases to address this international nuclear case, which continued until 2007, September 2, when the when the two accused were both convicted. We had to have two separate trials.
Until 2007.
Yes, that's correct. Now, what happened then when Advocate Simelane was appointed, he then assigned me to go and manage the block corruption case in the Northern Cape, but I continued to work on TRC cases, guiding investigations. I did make a decision in Advocate Simelane's time frame with the Craddock 4 case. Then the next step was with Mr. Nkosana, 2014-2015. He then removed me completely from the PCLU to work exclusively on the foreign bribery cases. But then as we've seen in the evidence, I still help my colleagues out on TRC cases when they're experiencing difficulties.
Just remind me again of the dates. It's
The nuclear case
yeah.
is either end of February 2004 at definitely March 2004, and the final case was concluded September 2007.
Okay, thank you. Then just another factual issue from me. I may or may not have read it in your affidavits. You approached the DPCI, who said that they would be willing to help with investigators after the World Cup.
That's correct, yes.
Now, I don't know where I read it, but I think it was in one of your affidavits that you said you soon found out they'd only appointed 3 investigators.
That was my recollection at the time.
When do they appoint more investigators?
As the cases progressed. But let me think now, this is 2010, so I was still dealing with 2010 up to 2013, but that's when I was taken away.
That's where you, and then we know it was only in 2020 or January 2021 that 40 dedicated investigators were made available.
They started being appointed in July 2021, not all 40 in one batch, but one by one people were being appointed. So that process started in July 2021.
Okay. Let me just check my notes. Yes, in 2019, you raised the concern about the lack or the poor quality of investigations. You raised this,
Yes.
amongst others, with the NDPP.
Yes.
And then I just want to confirm it was you who proposed the decentralized model.
That's correct. That was the only way I could have more prosecutors available, because there was a moratorium on filling vacant posts and creating new posts. And in any event, my view is it would be more cost effective and efficient if you had prosecutors in the region, because otherwise we would still be flying all over the country to do these cases. So it's a necessary expenditure, and you're coming in from outside, so you don't have that local environment. So I believe the local prosecutor would actually be more effective.
Thank you very much.
Mr. Bala, in your re-examination of Advocate McAdam, you will recall that when he was being cross-examined by Mr. Vani, he told us that he had certain documentation with him which he could make available to the Commission. Could you please, in your re-examination, make sure that you put those documentations on record?
Chair, I've not kept a list of that, but I think the transcript will reflect that. And with your permission, we'll just go through the transcript and make available whatever he says he has.
Yes.
We will certainly do so. We'll go through the transcript whenever it's available, and within a few days of that, we'll
Certainly.
Yes.
give you the documents.
But do you confirm, Advocate McAdam, that you are formally placing them on record before
Yes,
the Commission?
that is correct. It's very important that the Commission see those documents, because it's a dispute between myself, Advocate Jiba, and Colonel Makua in his evidence. So I think it's vital that the Commission see those documents.
Thank you.
Thank you, Chair. Chair, I have the graveyard shift, and I promise to just deal with 3 or 4 areas.
Yes, you may proceed.
Thank you. Advocate McAdam, in the examination by the evidence leader, Advocate Soni, he put propositions to you, and at least 2 of those were premised on this. Had proper resources been made available, it was put to you on a theoretical basis. In chief, you mentioned that there was a competition for resources on the ground,
Yes.
and in reality, was it sinister that those resources were not made available? Or were there simply competing cases and competing areas for those resources?
Correct, Madam Chair. All occurred when we actually were ready to investigate. And, you know, you did have, particularly with the DSO, this was before Advocate Ledwaba refused to investigate, but before, we said we've identified this with our team. If we have more staff, we can do more. The same thing when the DPCI started in 2010. Again, if they had more investigators, more experienced investigators, a lot of additional work can be done, because from 2010, when those investigations started, even though we might say some of them were not of high quality, there was no stopping of those investigations for any reason at all. It was simply restraint.
My question is directed at something else. He put a theoretical proposition to you. On the practical level, on the ground, were there other cases and areas that were competing for the same resources that the TRC investigations would require?
Yes, that's correct.
Yes. And are you aware of resources being withheld, deliberately withheld, or withheld with any ulterior purpose in relation to the TRC cases?
Not at all.
In relation to the cross-examination by our colleague, Advocate Varney, he elicited a fair deal of opinion evidence from you. And one of the areas that he covered with you was in relation to the question let me put this to you. You are one of those persons that have been longest involved in these investigations. Would that be fair?
Yes, that's correct.
And on this topic in relation to TRC investigations and cases, it appears that you have the most institutional knowledge of this. Is that correct?
Yes, correct.
Yesterday, you, under cross-examination, said whilst it was not ideal and not easy, work was done by the NPA and the police.
Yes, that's correct.
During your evidence under cross-examination, the following came through. I'm just setting the context for what I want to put to you. Those areas where things were not ideal were lack of continuity,
Yes,
resource constraints,
yes,
what I call turf wars, but personality differences
Yes.
that you've testified to, perhaps some degree of laxness,
yes,
and cases slipping between the cracks, to use
Yes.
some of the phrases you used. In your considered view, and in your overall view, was there any sinister interference or any evidence of that you saw where persons were trying to deliberately stop prosecutions of TRC cases with an ulterior purpose or motive?
Madam Chair, I was not involved in these matters in 2004, where Advocate Ackerman was prevented from proceeding with the prosecution and thereafter a moratorium was placed. I wasn't involved in only starting investigations once the guidelines had been approved. I was not involved in the task team except for one or two meetings that I attended. And as I said in my evidence, I struggled for almost a year and a half before the police undertook to assist me with investigators. But obviously, I don't know what informed why there was such a delay, because at that stage, the police were the only investigative agency available to investigate all crime. So I would leave that period, that I would not express any opinions at all. I would leave it to the Commission, having heard all the evidence, to make a decision what caused those events.
Yes, I think that's fair enough. I think the question was overbroad, really.
Yes, perhaps let me, in relation to the period that you were involved, are you aware of any evidence of deliberate intervention to stop prosecutions in TRC matters?
I take it you mean from an executive level, not
Yes, yes.
No.
And on that issue, in cross-examination, you were asked about executive intervention in prosecutorial discretion. That came up a few times
Yes.
in the examination by Mr. Vani. And you, Advocate Nguka, testified before the commission that people always lobby to influence prosecutions, but in his experience, or certainly while he was there, that never succeeded. In relation to what may be termed executive intervention to influence
Executive interference.
intervention, Mr. Varney used the
Intervention.
word intervention. In relation to executive intervention that he put to you, in the periods that you were involved, did that amount, in your experience, to stopping of investigations or prosecutions?
It comes back to the same point I've said, what happened 2004 up to
Yes,
the end. And
I
would,
prefaced it with when you were involved.
well, if we go back to 2003, no, and then definitely 2010, no.
And one of the terms of reference of this commission is to investigate whether members of the NPA or the police colluded with or succumbed to interference. In your experience and whilst you were there, did you come across any such collusion or succumbing to interference?
No.
Thank you, Chair. Those are our questions.
Thank you. Advocate McAdam, we thank you for having taken time to give this evidence before this commission,
Thank you, Madam Chair.
which will help us to be able to discharge our mandate.
Certainly, Madam Chair.
We appreciate your presence. You are now excused as a witness.
Thank you so much, Madam Chair. Could you make that a formal interdict preventing me from ever coming back here? Madam Chair, I just want to hear from Advocate Zoni. He asked me about these project plans and budgets and that. If they are required, I'll have to look for them and make them available. We have to, my shopping list is also these documents relating to Advocate Jiba and Colonel Makua. And then I
Yes.
must also go back to the MPA and raise the issue of prejudice were the commission to receive the instructions I gave to the police on the Nokatula Simelane matter.
Yes,
That's the sum total of all my homework.
thank you. These proceedings are adjourned until tomorrow at 10 o'clock.